All right, guys, if you were not here last time, I'm Andy Carroll, and I'm here today to continue with you your preparation for the Code 3 part of the exam. Again, I'm covering all of the non-commercial, non-security devices portion of the exam with you. So my contact information, again, is email is probably best, acarroll, ACARROLL, @law.lsu.edu, or you can get me by phone, 225-578-4254. I said yesterday that we have two outlines to do together each day. So today we're going to knock out contracts and mandate, shorter subject that is tested every single time. So we're going to start with contracts. Go ahead and turn to that. And as you're getting there, I'll sort of say that this, of all of our days together, may be the most painful one, unfortunately, because I think knowing how much to study or how to approach your study of contracts on the bar exam is a relatively tricky proposition. Up until a few years ago, contracts was tested not much at all on the bar exam. It represented about 5% of the Code 3 testing. So, you know, you've got a 20-some-odd page outline here that wasn't tested much at all. With the advent of these multiple choice questions recently, however, I mean, recently meaning the last 5 or 6 years, that hasn't been true. Unfortunately, almost all of the multiple choice questions when they test non-security devices subjects has been focused on contracts. And the reason that's unfortunate is, well, that contracts is tested more frequently now, so you need to spend a little bit more time on it. And that with the multiple choice questions, what the examiner has chosen to test is exceptionally nitpicky little minutia in contracts. So I think here you'll notice even more so than yesterday, and definitely more so than tomorrow, that there are all sorts of little details, again, sort of disjointed. Tomorrow, sales and lease, when you master 4 or 5 big concepts and you're good, because the same concepts are tested every single time. Not so much true on contracts. So with that daunting introduction, once again, let's get to it. So I think the first thing you need to recognize, top of page 1, is the relationship between contracts, what we'll review today, and the stuff that we reviewed last time, namely obligations. So when we talked and reviewed obligations yesterday, remember I said that obligations is the foundation of all personal rights and duties in the Civil Code. So it governs all debtor-creditor, obligee-obligor relationships, which includes obligations, yesterday, includes even the relationship, remember, between tortfeasors and their victims. So that's obligations. Remember from day 1 of your obligations course, contracts are just obligations that are created voluntarily. So contracts are a subset of obligations. And then tomorrow we'll cover a subset of contracts, namely sales and lease. And I'll remind you in just a second why remembering that hierarchy and that relationship is important. But it's sort of obvious already, I suppose, or I hope anyway, that the questions are not going to be segmented on the bar exam. So if you have a question regarding a contract, you're going to apply everything we're talking about today, everything we're reviewing about the contracts rules, but you're also going to apply all the stuff we reviewed yesterday about obligations. It's not like you're going to have an obligations question and then a contracts question. You're going to be applying both of the sets of materials together. It's just that obligations is broader than contracts, of course. All right, so what is a contract? You'll recall it's an agreement that creates, extinguishes, or modifies obligations. And again, as I just mentioned, it's a voluntary undertaking of an obligation. The reason that's important is because, again, of that relationship between contracts and obligations. Because contracts is a subset of obligations, contracts is governed by both the contracts rules and the obligations rules. And if you have, remember, a more specific type of contract, it's governed by 3 sets of rules. So a sale is governed by the obligations rules, the contracts rules, and the sales rules. You know all that already, no doubt. The thing that you need to remember here is what to do in the event of a conflict. And you'll remember the general principle of interpretation, statutory interpretation here applies, and that is that the more specific rule always trumps over the general. So if there's a conflict between a contracts provision we're talking about today and an obligations rule we reviewed yesterday, the contracts rule trumps. If there's a conflict between a sales rule and a contracts rule, the sales rule trumps. I'll show you some examples of when that happens and how it's tested in the bar exam. But the idea, besides, one rule conflicting with the other, is that they all apply over each other. A few more basic principles of contracts that you'll need to review before we start getting specific. And that is that because a contract is a voluntary creation of an obligation, it's the law for the parties. And so it can only be dissolved by their mutual agreement or for the causes that the law allows. We reviewed some of those yesterday, impossibility and all that. We'll do a little bit more today. In Louisiana, as in all American states, we have this sacrosanct principle of freedom of contract. So the thing that you need to remember on the bar exam for those purposes is that everything in here, everything we're reviewing, everything in the civil code, unless we say otherwise, is merely a default rule. The parties are allowed to contract around them. The only exception, you know, is that parties can't contract around rules of public order, rules of public policy, and I'll talk about those when we have them, but that's the exception. This is frequently tested. On a recent bar exam, the parties to a lease contract changed the rules in the civil code on who is supposed to make what repairs to the lease premises. Tomorrow I'll review what the rule is with you. But the parties changed it by contract, and then the examiner asked you who has to make the repairs. Your answer should be whoever the parties say so. Whoever the parties say is supposed to make the repairs under the contract, because these are all rules that can be contracted around. Again, unless they're it's against public policy to do so. Next, like general obligations, which we discussed yesterday, contractual obligations likewise are heritable, transferable to others, not just upon death, transferable during life as well. And finally, right, this is day one of your obligations course. There are 4 requirements that every valid contract must meet in Louisiana. Huge payoff on the bar exam for knowing these 4 and being able to apply them. This is a lot of what's tested on contracts, at least in essay format. Remember, those are capacity, consent, cause, and object. You must have all 4. If there's a defect in any of the 4, you do not have a valid contract in Louisiana. A lot of the essay portion of the exam, again, will be testing those 4 and applying them. So we'll be talking about each of them in depth in a few minutes, but we're not quite there yet. First thing we need to do is do the same thing we did yesterday with regard to obligations, and that is talk about the classification portion of the title. The examiner frequently, especially now on those multiple choice questions, just asks you to classify obligations. What kind of obligation, contracts. What kind of contract is this, and who cares? What's the effect of classifying it in a certain manner? Just black letter regurgitation questions. So you'll spill out the law that you see here. So the first distinction you will need to recall is between unilateral and bilateral contracts. If you have the most memory of your common law contracts course, you need to try to set it aside here because you're being tested on civil law contracts, and the civilian idea of a unilateral contract is not the same as the common law idea. So in civil law, a unilateral contract is a contract between an obligor and an obligee, but where there's no reciprocity. So only one party has a duty. You may remember in the common law, I say this only if it resonates with you, not to confuse you, that in the common law, when we think about a unilateral contract, we're talking promise for performance. Nothing to do with that in the civil law. In the civil law, unilateral contract is one in which only one party has a duty. So to have a contract, a unilateral contract is civil law, you need an obligor and an obligee, only one party is giving something. What that means, you'll remember, is that a donation is a contract at civil law. In the common law, it's not. In Louisiana, civil law, it is. Donation is a unilateral contract here. A bilateral contract, on the other hand, in Louisiana, obviously is precisely the opposite. Both parties reciprocally bind themselves. So each party is agreeing to render a performance. And the only importance of that really is in integrating it with what we already reviewed yesterday in obligations, right? That is, if in most contracts parties are reciprocally binding themselves, then in most contracts, each party is both obligee and obligor. So take a sales contract, for instance. Buyer in a sale promises to pay the price, seller promises to confer ownership to deliver the thing. So if you're talking about the buyer's position, he's an obligee with respect to the seller's duty to convey ownership. He's an obligor with respect to his duty to pay the price. Both parties are both obligee and obligor. Second principle that comes out of this idea that in a bilateral contract in Louisiana, both parties bind themselves is at the top of page 2, that because they're binding themselves reciprocally, their performances are correlative. They come together. The only reason one party binds himself in a bilateral contract is to get the performance of the other. Who cares? Well, remember that has effects when one party breaches. In a bilateral contract, if one party breaches, the other is excused from performing. They were reciprocally, co-relatively bound, so if one doesn't perform, the other one is not required to. Of course, he can sue for breach of contract and demand specific performance, but in the meantime, remember, he's not required to render the correlative performance. Next classification, the only way you're going to be tested on those is through like black letter multiple choice questions or a subpart at the end of a long question that says, what kind of contract is this and what are the effects of that given contract? Bar examiner often does that. Next classification that's important is between onerous and gratuitous contracts. You have already reviewed, I think, this distinction in Code 2 in the successions material, so you should remember it pretty well. We decide whether a contract is onerous or gratuitous based on the motivation for the obligor's performance. So if the obligor is taking on a performance solely to get something for himself, then that's an onerous contract. If his motives are to bestow a liberality on someone else, give a gratuity to another, then it's a gratuitous contract. Here, all I'm doing is drawing the distinction between an onerous and gratuitous contract. I can't tell you in an instant the distinction between the two because there are 5,000 reasons that it matters. We'll see as we go along. It matters for error, matters for form requirements, matters for many, many, many reasons. So we'll belabor that as we go along, but recall the difference for now. Principal and accessory contracts, I mentioned yesterday, huge principle that you'll be tested on myriad times on Code 3, so absolutely make sure you master it. Has implications in several areas. Remember, an accessory contract, as defined in the Louisiana Civil Code, is a contract designed to provide security for another obligation. So it's accessory. Its entire existence hinges on the continued existence of some principal obligation. And the most important effect of an obligation, classifying an obligation as an accessory, we discussed last time. That is, extinction of the principal obligation automatically extinguishes all accessory obligations, right? So yesterday I said, extinction by whatever cause, impossibility, compensation, confusion of the principal obligation extinguishes suretyship, mortgage, pledge, pawn, all of the accessory obligations. You'll review that in suretyship, security rights in the next couple days as well. You need to know the difference between nominate and innominate contracts. A nominate contract is the one that's given a special name and special regulation in the Civil Code. An innominate contract has no special name. Who cares? Well, remember the significance of the distinction is not really the name, but whether there is a separate special set of rules that applies to this particular contract. So nominate contracts, for instance, have three sets of rules that apply to them. Obligations rules, contracts rules, and let's say my nominate contract is a sale, for example. Sale has a special name, special definition, special set of rules in the Civil Code that apply to it. Lease is a nominate contract. I hire you to sing at my child's birthday party. That's an innominate contract because it doesn't have any special name or special set of rules that apply to it. It's just a contract. So only the contracts rules are going to apply. Bar examiner tests that frequently. Describe a nominate contract and give examples. So simple regurgitation. You see what I'm saying in contracts, little nitpicky stuff that you have to remember, unfortunately. Very rarely, the examiner will give you one of these last two types of contracts listed on page 2. I haven't seen a question calling for discussion of a commutative contract in more than 15 years of old exams. But just in case, it's in theory, this is the problem, contract in which the performances are correlative to each other as opposed to the obligations themselves. You may already get, if you're paying attention, that the reason it's never tested is that there's a big theoretical problem between with the difference between that and a bilateral contract, because that sounds exactly like what a bilateral contract is. In theory, in a bilateral contract, the entire obligation is correlative rather than the performances. This is why the examiner never tests it, because nobody really knows what it is in Louisiana. The bar examiner does, though, so I haven't, again, more than 15 years of exams, I've never seen him ask you about a commutative contract. Every 5 years or so, though, you'll get a question on an aleatory contract at the bottom of the page. So just grasp what it is. It's sufficient for you to know the definition and the two most common examples that are always tested on the bar exam. So the definition of an aleatory contract is one in which either the existence of a party's performance or the extent of his performance. That latter part everybody forgets. The existence of a party's performance or the extent of his performance depends upon an uncertain event. Now, the only difficult part, I think, here is distinguishing this from what we talked about yesterday, and that is an obligation subject to a suspensive condition, which also hinges on an uncertain event. They are not the same thing. And when the bar examiner has tested it, he's trying to test you on the distinction between obligations subject to a suspensive condition and aleatory contracts. So remember from yesterday, when you have a conditional obligation, the very obligation itself, the duty for both parties, hinges on an uncertain event. So an example I gave you yesterday was, I agree to sell you my house if I accept a transfer of my employment to New Orleans. If we fulfill that condition, if that condition is fulfilled, then both of us are bound. I'm bound to sell you my house, you're bound to buy. If the condition fails, I don't have to sell to you, you don't have to buy. The entire contract, both of our duties, depends on the uncertain event. In an aleatory contract, in contrast, it's not the entire obligation, but just the performance or the extent of performance for one party. So two examples, you've got one listed here. The classic example, and most tested on the bar, of an aleatory contract is an insurance contract. I have car insurance, right? If some loss-causing event does not happen during the policy term on my car insurance, then I'm not going to get my premiums back. I mean, my duty as the insured is certain. I pay my premiums no matter what. But the duty of the insurer is contingent upon some uncertain event. He may have to pay me if I get in a accident, if I get in an accident that's covered by the policy. The duty of one party, not both, hinges upon some uncertain event. That's the classic example. The other example, again, that's more forgotten, is that you also have an aleatory contract when the extent of one party's performance is uncertain. So the classic example of that is, I contract with my aunt to take care of her for the rest of her life. That is also an aleatory contract because the existence of anybody's duty is not hinging upon some uncertain event, but the extent of performance is. No telling if Aunt's going to live 5 years or 35 years. So the extent of my performance depends upon some uncertain event, namely the time of her death. That's it for basic classification. Again, the way that you'll be tested on those first 2 pages of material is largely through multiple choice, maybe a subpart at the end of an essay question, just asking you to classify. All tested the same type of way. All right, next thing we need to take up on top of page 3 is where you want to spend almost all of your energy. This and vices of consent, so the next 10 pages of the outline or 8 pages of the outline, extremely important. It's the bulk of the testing of contracts. We're going to take up first those 4 requirements of a valid contract: capacity, consent, cause, and object. So let's start with capacity and review the rules here. You'll recall first the general rule. I don't know that it's clearly stated except for the all persons language at the top of page 3. But the general rule is that everyone has capacity to contract. The exceptional rule is a deprivation of capacity. And there are 3 general categories of persons that will lack contractual capacity. Of course, everybody else has it. Those states are minority, interdiction, and being a so-called person deprived of reason. We always call it a PDR for short, at the time of contracting. So let's talk minority first. You'll recall that not even all minors are deprived of capacity. Specifically, it's only unemancipated minors that lack capacity to contract in Louisiana. You already reviewed, I hope, emancipation in Code 1. You shouldn't be tested in Code 3 on whether or not or how a party becomes emancipated, right? You'll just be told the minor is emancipated or not. If your minor is not emancipated, he lacks contractual capacity. That's the general rule, at least. But there are a few exceptions, and these exceptions, at least 2 of them, are frequently tested on the bar. So know the exceptions. One of them was just tested in February of 2014. So first exception, that is scenarios in which we will uphold the minor's contract despite a lack of capacity. First is if an unemancipated minor enters into a contract with a person that has reasonably relied on the minor's false assertion that he's a major. He lacks capacity, but will uphold the contract anyway. So you need 2 things, a representation of majority, a lie, and a reasonable reliance on that lie for this exception to work. So classic example is minor shows a good fake ID. Right? It needs to be a good ID because you need reasonable reliance on it, and that's a representation of majority showing a fake ID. And that's the example usually used on the bar. Second, and even more frequently tested on the bar, if a minor enters into a contract that's related to his business or necessary for his support or education, the contract will be upheld despite capacity problems. So minor's got a lawn mowing business over the summer and he goes and buys a $1,000 lawnmower, later has a change of heart and wants to rescind. He generally could because he lacks capacity, but if it's found to be a contract relating to his business, will uphold anyway, regardless of the lack of capacity. Finally, there are some special rules on what sorts of gratuitous contracts a minor can make. Donations, for example, those you probably already reviewed in your review of successions. That's the only one of these 3 exceptions that has never been tested here on Code 3, likely because it should be saved for Code 2. So unless one of these exceptions applies, if an unemancipated minor enters into a contract, it's a nullity. Relative nullity, later we'll talk about the types of nullity and the consequences of those, but it's null because it lacks one of the essential elements, capacity, cause, consent, object, lacks one of the essential elements of contract. Interdiction is also a cause of capacity. I'm sort of between the 2, between number 2 and number 3, not even on number 3 yet. Interdiction is also a cause of incapacity. Here, in this section of the bar, all you need to know is that interdiction deprives you of contractual capacity. Shouldn't be tested on anything else because you already reviewed, again in Code 1, how interdiction might happen. The details of the testing of interdiction should occur in Code 1, not here. But if you have an interdict, likely it's only going to be tested through multiple choice. He lacks capacity to contract. Finally, number 3, tested frequently. Persons deprived of reason, I'll call them PDRs from now on, cannot make valid contracts. First thing you need to recall is what a PDR is, defined in the Civil Code. Generally, these are people who have some problem that may even make them eligible for interdiction, but no judicial process has occurred yet. So somebody with Alzheimer's, dementia, whatever, those people that would qualify for interdiction as well, likely, might be PDRs. But remember, in Louisiana, it could be something much lesser, like being drunk or high at the time of contracting. And that's usually the example the bar examiner uses, drunk or high. If a party was so drunk, so high, that he was a PDR, deprived of reason, at the time of the contract, then there's no valid contract because the capacity requirement is not met. However, you may remember from your law school studies here that the causes of being a PDR in Louisiana are so broad that there's a major restriction here. That is, we only allow an onerous contract. Here's one of those times where it matters whether your contract is onerous or gratuitous. We only allow an onerous contract to be rescinded by a PDR when the other party knew or should have known of the problem. All right, so you can't get out of any old contract saying you were drunk. You have to prove that the other party knew or should have known that you were drunk. You may remember some of the cases call this the notoriously insane requirement, meaning it has to be obvious to the other person that you're out of your mind at the time of contracting, otherwise you won't be able to rescind. Gratuitous contracts, on the other hand, can be rescinded by the PDR without any knowledge in the other person. So it's a heightened burden of proof for the PDR seeking to rescind an onerous contract here. All right, so let's assume that we prove up a ground of incapacity. We've got an unemancipated minor, interdict, PDR. What's the result of it? Well, I just said that the contract will be a nullity. because it lacks one of the 4 essential elements of contract. Look at number 4 at the bottom of the page. It's a relative nullity, not an absolute nullity. If you're a student of the common law, the distinction there is void versus voidable, but you are not going to use that language on the Louisiana bar exam. You must say absolute nullity, relative nullity. The examiner frequently, by the way, asks you what's the difference between the two, set out all the consequences of absolute versus relative nullities, which we'll be talking about in a few minutes. But for now, capacity leads to a relative nullity, which has lots of consequences, which we'll be discussing. Relative nullity, somebody has to go to court to have it declared, and if they don't do that, the contract stands. Right, so minor enters into a contract, that's a good contract, unless and until the minor goes to court to have the nullity declared. And don't forget, only one person can do that. That's what's in number 4 here. The only person who can set aside a relative nullity is the party in whose favor the nullity exists. So that's your minor, interdict, person deprived of reason. The other party to the contract cannot set it aside. That's a consequence of a relative nullity. More on that later. All right, so there's your first requirement of a valid contract, capacity. Second requirement that you need to review in Louisiana is consent, which you'll remember is manifested through the process of offer and acceptance. So first thing you need to recognize is what's in this first sentence under consent. In Louisiana, there are no form requirements for offer and acceptance generally. Right? Can be done anyway, orally, in writing, possibly even by action, a tacit offer, tacit acceptance. That's the general rule. However, don't forget that that proof of obligations section that we reviewed yesterday gives form requirements for certain agreements. So transfer of an immovable, for instance, has to be in writing. Compromise has to be in writing. So if the offer and acceptance relate to an underlying contract that has to be in writing, the offer and acceptance must as well. I gave you the classic bar exam example of that yesterday. That is, guy sends a written settlement offer and the recipient calls up and tries to accept it. Examiner asks you if that's a valid contract of compromise. Answer is no, because compromise requires a writing. Both offer and acceptance must be written. Absent that, right, absent some special relationship that requires a particular form, anything goes, writing, oral, again, sometimes even inferred offer and acceptance based upon your action or inaction. It just has to be indicative of your intent to be legally bound. All right, if you remember that basic rule, then you can look at the top of page 4. We break it down into offer and acceptance. They're subject to a couple of different rules. So let's take up and review the offer first. To be valid, it has to be serious, right? Remember, not in jest. And it needs to be indicative of intent to be bound. You'll remember that we distinguish that from invitations to negotiate, right? So you have to evince a willingness to be bound if it's accepted. It can't just be an invitation to negotiate. So look at the first sentence at the top of page 4. Unlike a contract, an offer is not heritable or assignable. It's personal to the offeror. So who cares? Remember, bar examiner tests on this relatively frequently. If the offeror or offeree dies before a contract is formed, the offer dies too. So the same is true if either party becomes incapacitated, interdicted, or PDR or whatever before a contract is formed. So the contract will survive the death of a party, but an offer will not. You have to have a valid contract for it to survive. Offers, you'll remember, are either revocable or irrevocable, and this is not listed in your outline, I don't think, but is important, so write it in. Our default rule in Louisiana is revocability. So you're always going to start with the principle that an offer is revocable unless there's something special that makes it irrevocable. Then what is in your outline focuses on what makes the offer irrevocable. So a couple things would do that. First, if the offeror specifies a period of time for acceptance, then the offer will be irrevocable. Right? So offeror says, here's the offer, you have 3 days to think about it. That's an irrevocable offer for those 3 days. Second, if the offeror does not specify a period of time for acceptance, but he demonstrates an intention to give a period of time, that's an irrevocable offer. So I say, here's my offer, think about it for a while and get back to me. That will be an irrevocable offer. That's number 2. Number 3, if the contract says, not the contract, if the offer says absolutely nothing at all about any time period within which to think it over, some courts will still find an offer irrevocable, remember, under the doctrine of implied irrevocability. And usually implied irrevocability applies where the offeree needs some time to accept, like he needs to get the acceptance of his home office, or he needs to do credit checks because it's a financed sale. The offer might be irrevocable under those circumstances, even though nobody said anything indicating as much, because it's implied that some time will be required before an acceptance can be lodged. Generally, though, don't forget, offers are revocable. So you're looking for one of these 3 things, some intent or some implication about giving a period of time to accept. Assuming you have the norm, that is a revocable offer, it can be revoked at any time prior to acceptance. And revocation is effective upon receipt. That's the middle of page 4. An irrevocable offer, of course, is irrevocable. It cannot be revoked within the stated time, or if the offer does not state a period of time, this is B at the top of page 4, the rule is a reasonable time. Now, you'll recall here how long is reasonable, of course. We have no black letter law on that. It depends on the circumstances of the parties and the type of contract. So if they're having a face-to-face discussion, it's over movable property, for instance, then a reasonable time would be much shorter than it would be for immovable property where the parties are at arm's length or whatnot. So you need to apply everything you know here about the fact dependency of reasonableness. Both types of offers, both revocable and irrevocable offers, expire if they're not accepted within a reasonable period. This is number 3, expiration of the offer. They expire if they're not accepted within the time listed or within a reasonable period if no time is listed. Obviously, a revocable offers, let me say it like that, are never going to list a time. If they did, they would be irrevocable. So those are always going to be subject to the reasonable time rule. All right, the way all these rules are tested, of course, is that the examiner will give you the details of the offer, give you one little paragraph on potential acceptance, and then ask you whether the parties have a contract. So what you need to be talking about is things like, was the offer still alive at the time of acceptance? Be sure it wasn't revoked or didn't expire before the acceptance became effective. All right, so there you've got offer. Let's move on to acceptance. And the big question here is, how is an offer properly accepted? And the answer, unfortunately, remember one more time, depends on the characterization of the offer. All right, to know how you can accept, you have to know what kind of offer you have. And here again, you have to distinguish between revocable and irrevocable offers. I could not emphasize more the importance of these rules. They're tested all the time. We're just tested on the February exam. It's because the rule departs from the common law. So that's why you need to know it. Idiosyncrasy of Louisiana law. The rules on the effectiveness of acceptance. So the rule is here, let's take the revocable offer first, number 4. The acceptance of a revocable offer is subject to the common law mailbox rule, which you'll remember means that it's effective upon transmission, as long as the offeree uses the manner and medium suggested by the offer or some other reasonable means of transmission. Mailbox rule. When you put it in the mail, that is for a revocable offer. The offeree in a revocable offer can accept by the mailbox rule, that is merely by transmission. If, on the other hand, so far no distinction from the common law. Here's your big change for Louisiana. If, on the other hand, you have an irrevocable offer, an acceptance of it can be effective only upon receipt by the offeror. The mailbox rule does not apply in Louisiana to irrevocable offers. It's not effective on transmission. Acceptance is effective upon receipt. Remember, we're basically, for irrevocable offers, placing the burden on the offeree to make sure that the offeror receives the acceptance before we'll say there's a contract. Again, just tested in February of this year and tested very frequently because it's one of those distinctions. The examiner wants to make sure you know the particulars of Louisiana law. So pay some attention to that. Look back at the old exams for examples. All right, that's all. I've been talking thus far only about acceptance by words. You'll recall from your basic contracts course also that acceptance may be made under certain circumstances by performance. instead of words. And there's some special rules in Louisiana that you need to be familiar with on that. Remember, acceptance by performance will come into play when the offeror has made an offer and it's clear either from the circumstances or from his words that he wants acceptance by performance and not by words. You'll remember here that the rule is that the offeror is the master of his offer. So he can say how he wants acceptance. And if he says acceptance by performance and the offeree tries to accept by words, not good enough. Offeror is the master of his offer. So if it is clear, either by his words or his conduct, that he desires acceptance through actual performance, then only the performance he requests will be deemed as acceptance. Right, so let's look at number 2 first, acceptance by the completion of performance. For example, the offeror says, you can accept this contract, I want you to repaint my house. You can accept this contract by showing up and completing the project. Right, that would be acceptance by completion of performance. Under those circumstances, we will say that the offeror cannot revoke the offer. There's no contract yet until the performance is complete. Once performance is begun, right, still no contract because we need the completion of performance. But it would be unfair, of course, to the offeree to allow him to begin performance and then get screwed when the offeror changes his mind. So what we do is make the offer irrevocable for a reasonable period of time. All right, so if you have to complete, if the offeror's language suggested that performance needed to be completed, no contract upon the commencement of performance, but an irrevocable offer instead. Go back up to number 1. If the contract suggests, and again, it only matters what the offeror says or implies. If he says or implies that merely the commencement of performance is sufficient, you can show up, I want you to paint my house. You can accept by showing up and beginning the work on Saturday. When the offeree shows up and begins performance, there's an immediate contract because that's what the offeror suggested. Right, so acceptance by completion, acceptance by commencement depends on which you have. In completion, there is no contract but an irrevocable offer. In commencement, immediately upon the commencement of performance, we've got a contract. Number 3, bottom of the page. It may be in both of those situations that the offeror does not know that the offeree has begun performance, and that either a contract has been formed or an irrevocable offer has been created. So we have this duty to give notice. The offeree is required to give notice under these types of contracts or these types of offers when he begins performance. Now be careful, the notice is not the acceptance, because the acceptance can only be performance, right? So the offeree's failure to give that notice doesn't affect the validity of the contract, but you're supposed to give it, and if you don't give it and the offeror is prejudiced, that may give rise to liability for damages, whatever the offeror suffered because he didn't know that the work had begun. So for instance, he went out and contracted with somebody else, had to pay a deposit for somebody else to do the work, not knowing, for instance, that you had commenced performance, perhaps damages for that. But it does not affect the validity of the contract. All right, top of page 5. A few minutes ago, I said no particular form is required for an offer. Even action or inaction instead of words will sometimes suffice, which brings us to the possibility of acceptance by silence. So can acceptance ever occur by complete silence? Remember, the rule in Louisiana is yes, but rarely. There's no form requirement for acceptance, so silence could be enough, but only if the silence has led the offeror to reasonably believe that the offer was accepted. And you'll recall in the real world, that likely requires some past practice between the parties. I mean, it's not generally true that you would take someone's silence to be an acceptance. So for you to reasonably believe that it is, there probably needs to have been some history of dealings between the parties that implied as much. That's a very narrow rule, though, right? So don't forget, I mean, I have in the outline acceptance by silence, but it's very rare that acceptance will be formed by mere silence. Generally, we require some affirmative statement or act. What do we do with non-conforming acceptances in Louisiana? Well, remember, the general rule here is that if the offeree purports to accept an offer, but the acceptance is non-conforming, that is, he adds terms, he changes terms, that is not a valid acceptance at all. The black letter rule is that we follow the mirror image rule in Louisiana, right? Remember that from day one of common law contracts. The acceptance has to be the mirror image of the offer, and if there's any little change, no contract at all. The acceptance is not an acceptance, it's instead a counteroffer. You'll remember, I've got a note here, that there's one narrow exception to that in sales of movables, which we'll discuss tomorrow. It's based on that UCC 2207, the battle of the forms and different terms and all that business. We'll review that tomorrow. We depart a little bit from the UCC rule. But in the absence of a special rule for sales, we apply the mirror image rule. So for basic contracts, mirror image rule, a deviating acceptance ain't an acceptance at all. It's merely a counteroffer. That rule is tested pretty frequently, so be on the lookout for it. It's tested both in the general rule context and in the exceptional context for sales of movables. So know it in both places. Finally, think about offers of reward. In Louisiana, they are binding on the offeror, just like any other offer. And the really important thing that you need to recall, remember we're still under acceptance here, is that even if the person who performs doesn't know of the offer at the time of the performance, the offer is still binding on the offeror. He has to pay somebody who performs under it even unknowingly. That brings us to, that's the only thing that's ever tested about offers of reward. So that brings us to our third requirement of a valid contract in Louisiana. You've reviewed capacity, you've reviewed consent. The third requirement is cause. This one is tested on all the time. It's a favorite of the bar examiner. You already know why, right? Because it doesn't exist in common law jurisdictions. It's kind of, if we have to categorize it, our substitute for consideration. So you will not ever use the word consideration on the Louisiana bar exam. You will speak only of cause instead. Favorite of the bar examiner. It's not usually tested, I have some rules set out here on cause. It's not usually tested just by itself. Rather, it dovetails in with error. And so it's usually tested in the context of error. So we'll review it here, and then you'll see what I'm talking about in just a few minutes when we get to error. So memorize the definition of cause at the bottom of page 5. It's short. You need to know it. You will use it. In Louisiana, cause is simply the reason why a party binds himself. So again, if you're common law trained or you have the best memory of common law contracts, in terms of function, remember cause serves the same purpose as consideration. That is, it's supposed to help us weed out what kind of promises are enforceable and what kinds are not. But in a very different way, right? In the common law, we weed out any promise in which the promisor doesn't get something in return. We don't care about that. At civil law, all we care is that you have a cause. Right, so the civil law asks, the cause requirement is, does the promisor have a valid reason for binding himself? And if he does, that's good enough. That's the cause requirement. It can be a gratuitous reason, it can be an onerous reason, doesn't really matter. He just has to have a reason. So don't forget, one of the reasons cause is useful then, look at A, is that it helps us to distinguish between onerous and gratuitous contracts. Now again, should I keep beating the horse? That's not to say that we don't enforce gratuitous contracts, we do, but there may just be a heightened form requirement, right? So cause is important in distinguishing between the two. Are you doing it to get something in return or just to bestow a liberality? Second function of cause, I just mentioned, is in the area of vices of consent, particularly error. So we're going to review error in just a few moments, and when we do, to ask whether you should be relieved of the burdens of contract because of error, we're going to ask what your cause was and how vital the error was to your cause. More on that in a few minutes. Top of page 6, the third function of cause is in the area of illegality. That is, it helps a judge to identify promises that should be struck down as violative of public policy. Right? So if your primary motivation in binding yourself was to get something illegal, a sales contract for drugs, gambling in Louisiana, the contract will be invalid because it has an unlawful cause. That's never been tested in a fact pattern on the bar exam, although it has appeared in those multiple choice questions, right? So you're tested just on the black letter law. What you do need to remember, and what is tested relatively frequently on the bar exam, is this number 3 at the top of page 6. That is, in determining what the party's cause is, a court is not limited to the party's recitations of their motive. So parties may not express their cause in a contract at all, or more likely, they may lie about their cause. And what you need to remember in Louisiana is that's perfectly okay. You can lie about your cause. First, you don't have to state a cause. You have to have one, but you don't have to state it. And second, you can lie about it. If you lie about your cause, that's called, remember, a simulation. But there's an example at the top of page 6. We're going to review simulation again later. It comes up in sales. But there's an example on the top of page 6 that should help you for now. There are actually 2 different types. If you have a contract that the parties call a sale, but we determine that the ostensible seller never really intends to collect a price, perhaps because the buyer is his favorite child and his intention all along was really just to donate the property to the child, but he didn't want to say that. It's not really a sale. It's a simulated sale. There's a lie about cause. You said it was a sale, but really what you were thinking is that it was a donation. The point here, what you must remember here is that's okay. Simulations are valid in Louisiana. The only requirement is that you meet the form requirement of the contract you intend. Right, so if you say it's a sale, but you're thinking it's a donation, you're intending a donation, you must meet the donative form requirements, which again are sometimes higher, as you know. Right, so you don't have to state your cause need not be expressed, and even if you lie, a simulation, it might be valid as long as you meet the form requirement. All right, you need to, I should have said at the beginning of this whole section on cause, the first sentence in the materials on page 5 says that you either have to have a cause, or as an alternative in Louisiana, you can have detrimental reliance. So that's what number 4 is. It's an alternative to cause in Louisiana. Some say it's even an alternative to contract, but you're not going to be tested on that distinction on the bar exam. We stole it from the common law. The basic idea is that when someone has made a promise outside the context of contract, for some reason it's not enforceable in contract, that may still give rise to a remedy for detrimental reliance, even though you can't sue in contract on it. So there's an example from a Texas case on which we based our entire theory of detrimental reliance in Louisiana. You may remember this one. Guy living in Texas is induced by an owner of the gas station to move his whole family to Louisiana and run the gas station. So he does, right? Gets everybody, collects everybody, moves all the way over to Louisiana, and a couple months later, the landlord cancels his lease of the gas station, as he had the right to do under contracts law and lease law, because the lease was just month to month, no fixed term, kicked the guy out. At the time that case was decided, the dude who moved over had no contract remedy, and we had no theory of detrimental reliance. So the court created a theory of detrimental reliance, and then the legislature approved of it. Right? The idea is that when you can't recover for breach, but you're abused by relying on some promise to your detriment, that you should still get recovery. So it's based on that case. Remember, detrimental reliance in Louisiana says even though contract law would give you nothing, if you rely reasonably on a promise to your detriment, then, big distinction, you can at least recover your expenses. That's the major principle that's frequently tested when detrimental reliance is tested. That is, all you're getting is a recovery of your expenses. We're going to discuss later today full contractual remedies. You get the loss you sustain, the profit of which you've deprived, profit of which you were deprived, all sorts of good stuff. You don't get all that in detrimental reliance. You only get your expenses. It's an alternative to contract. So know these requirements. I've belabored them, right? You need a promisee that relies on a promise to his detriment. You need a promisor that knew or should have known that that reliance would occur. And again, it needs to be reasonable reliance. You get back only expenses, not full contractual remedies. All right, just one more requirement of a valid contract. So we've got capacity, cause, consent. Number 4, last one, is the object. Right? You want to test all 4 of them. You have to have an object to have a valid contract, and the object of the contract refers to the performance that the obligor is supposed to collect from the obligee. It doesn't have to be a thing. Of course, it could be a personal service. I hire you to sing at my kid's birthday party. But the rule on object here is that it needs to be lawful, possible, and if not determined, then at least determinable. Otherwise, anything goes. Lawful, possible, and either determined or at least determinable. There's nothing in your outline. I'm sort of between, I guess, maybe that next sentence, although Not even, really. There's nothing in your outline about the requirement that the object be lawful. I would add a note to yourself that the requirement of lawfulness is probably broader than you think. So, I mean, obviously an unlawful object would include a contract for the sale of drugs. Be unlawful cause, but also unlawful object, right? So anything that a criminal statute prohibits clearly would be an unlawful object. But what you may not remember, and need to for bar purposes here, is that courts have tremendous power as arbiters of public policy to declare an object immoral, inappropriate, and therefore unlawful. And the example that the bar examiner likes to test relatively frequently is non-compete agreements. In Louisiana, they're allowed, they're not unlawful, but there are very, very strict standards for non-competes to be enforceable in Louisiana. They're heavily disfavored here because they prevent a party from making a living. So because of the strong, growing policy against broad non-compete agreements, if the bar examiner gives you a really broad non-compete, right, you can't work for any other pesticide company forever in the entire state of Louisiana, that's going to be an invalid contract. You want to say that it likely has an unlawful object. So it's not just things that are prohibited by criminal statute, but also things that may be against public policy. All right, that's lawfulness of the object. Let's move on to possibility. This is that second sentence still under the general paragraph under object. The contract in Louisiana has to involve a performance that the obligor can render. Has to be a possible performance. And you must remember this rule. Huge distinction from the common law, so know it. Performance is only impossible in Louisiana if it would be physically impossible for anyone in the world to perform. So we do not have in Louisiana a doctrine of impracticability. Remember, in the common law, you may be able to get out of a contract if performance would be so expensive that it would bankrupt you. It's impracticable. Doesn't matter. In Louisiana, we'll hold you to it anyway. Too bad, go bankrupt. Right? The idea is that it's only impossible if nobody in the world could perform. It's physically impossible for anyone to perform. So performance is much more onerous in Louisiana than it is in common law jurisdictions. Narrow, narrow, narrow doctrine of impossibility. All right, number one, at the bottom of page 6, finally, the object of a contract has to have a certain level of determinacy as well to be valid. That is, it has to be determined as to kind, but only determinable as to quantity. Determined as to kind, determinable as to quantity. When is it determinable on quantity? Well, determinable, for example, if the parties name a third party that will designate a quantity at some future time, or if the contract is an output or requirements contract. You remember these? An output contract is I'll sell or I'll buy all the widgets that you make this year, right? All the output that you make. I'll buy everything you make. Requirements contract. I'll buy all the widgets I require of you this year. In both of those cases, valid contract, because even though my quantity is not determined, it's determinable based on some third party or based on output or requirements. Top of page 7, even a future thing is a permissible object of a contract in Louisiana. But you'll see when we get to the rules on sales and review those tomorrow that if the thing is not yet in existence, its coming into existence will be a suspensive condition. So valid contract, but may be subject to a suspensive condition. The last stuff on object, I call it the French section, number 3 and number 4, a promesse de port for and a stipulation pour autrui. The examiner for the last examiner we had was fluent in French and so liked to test these things, and the new examiner happens to be as well. So lucky you. A promesse de port for, that doesn't mean you necessarily have to use the French. I'm sure you can do fine without using the French language at all. Nonetheless, the French section. Promesse de port for, let me talk about both of them in general. First, both of them. Promesse de port for, third-party beneficiary contract, involve bringing third parties into the contractual relationship. You're just doing it in different ways. So think of them together, think of them separately. A promesse de port for involves an obligor promising that performance will be rendered by a third party instead of or in addition to himself. But the third party is not a party to the contract. So basically, in a promesse de port for, we've got a third-party designation on performance coming from the obligor. and that third party is supposed to render the performance now. For example, I contract as obligor with you, my obligee, for a performance. I say, I'll paint your house. A promesse de port for would be me, the obligor, saying, I promise that Joe is going to paint your house instead. Right? It's a promesse de port for because I've promised that performance will be rendered by a third party. Most important effect, here's what's tested, is that the third party is not bound. The third party in a promesse de port for is not bound because he makes no contractual commitment. And the big kicker here is that you remember the difference between this and assumption, which we talked about yesterday, right? That's where it gets tricky here. In an assumption, the third party is bound, right, because he signs on to the contract. In a promesse de port for, the obligor designates a third party for performance, but the third party never promises to perform, and so he is not bound here. So if Joe fails to paint your house, for instance, then I, the original obligor, have breached. You can sue me, but you can't sue Joe. Secondly, the obligee has no cause of action against the third party to compel performance, again, because he's not in privity of contract. Sue the original obligor, not the third party. Now, there's only one thing that might change that, and that is it's possible that after I make the promesse de port for, I say, Joe's going to paint your house, the third party could come in and promise to perform, sort of affirm the promise that I've already made. And if he does, this will relieve the original obligor. But the original obligor is on the hook unless and until that ever happens. Finally, on object, we have the third-party beneficiary arrangement. Again, this is also a situation in which a third party becomes involved in an existing contractual relationship, but this one's treated differently from a promesse de port for because here the obligee has bestowed the benefits of a contract on a third party. So in a promesse de port for, the obligor imposes the duty on somebody else. In a third-party beneficiary, the obligee imposes the benefits, or I guess imposes is not even the right word, confers the benefits of a contract onto the third party. Third party is not bound to do anything, rather he's getting a benefit. So for example, I'll give you the example that was in the materials yesterday for good reason on assumption. That is, the assumption example is, write it down if you want here, it's in the assumption outline, but not here. I buy property from Jack on a credit sale, and then I sell to Jill and I tell her to pay Jack. I buy from Jack in a credit sale, I sell to Jill and tell her to pay Jack. That is the example that was in your materials yesterday for assumption of an obligation. Jill promised me that she would pay Jack. That's an assumption. It's also a third-party beneficiary arrangement. You need to be talking about both on the bar exam. That is, when I sell the property to Jill as her seller, I'm the obligee on her duty to pay the price, but I've stipulated that she should pay the price to Jack instead of me. I have designated a benefit to a third party. Now, obviously, I get something out of it, that is relief on my duty, but that's okay. You don't have to be doing a third-party beneficiary arrangement gratuitously or anything, right? What's an assumption may also be a third-party beneficiary arrangement. Just depends on the perspective that you're looking from. Unlike the promesse de port for, where the third party is not brought into the contract unless he makes an outright promise, the third-party beneficiary arrangement is favored in the law. Louisiana Supreme Court likes it, upholds it with great regularity, and the important part here is once there's any sort of manifestation by the third party that he's willing to accept the benefit, he's fully brought into the contract, but solely for the purpose of receiving that benefit. So he's not held to any duties because he hasn't made any promise to perform, but he has this is B, he has an action against the promisor to demand performance. Right? So on my example again, where I owe Jack the price on a home, but I sell the property to Jill and tell her to pay Jack, when we were talking about assumption, yesterday, we concluded that both Jill and I stay on the hook for the purchase price. An assumption does not release the original obligor. So we're both now bound to pay Jack, and the third-party beneficiary rules give Jack an action against Jill. Even though Jill didn't promise Jack anything, she promised only me. Jack was not a party to that contract. Doesn't seem like he should be able to enforce it, but the third-party beneficiary arrangement, when he manifests an intent to accept that benefit, brings him in, gives him an enforcement action. And additionally, this is the revocability of the stipulation. Once the beneficiary agrees to accept the benefit, the stipulation can't be revoked without his consent. Again, the third party is brought into the contract on a third-party beneficiary arrangement. Much more favorably treated in the law by Promes Deport 4, greater enforceability rights. With that, we will move on to the vices of consent after you take a 10-minute break. right, we are picking it back up at the bottom of page 7 with the vices of consent. And you need to remember, first of all, in Louisiana, that there are 3 full-blown vices of consent that apply to every form of contract. Those are error, fraud, and duress. Again, cannot really overstate the importance of these. Duress, not so much, is tested every 3 or 4 years. Error and fraud are tested every single bar exam. So I would note every single detail in the outline about error and fraud. You will use it absolutely for good reason, which I'll review tomorrow, namely that redhibition in sales is a unique Louisiana concept that's tested almost every single bar exam. And the heart of redhibition, one of the requirements of it, is error. So it necessarily raises issues of error and then likely fraud as well. So know the materials on error or fraud. You'll be putting your time to good use here. All right, 3 vices of consent. We'll start with error. And don't forget, of course, that consent is one of the essential elements of contract. So if you find that you have a vice of consent, contract's no good. It's going to be a nullity, relative nullity. We'll talk about the consequences of that later. Error. It is possible, remember, that error be some sort of mistaken belief that both parties held. And if that's true, the civil law calls it a bilateral error because it is something that both parties suffer from. The parties have the right to change their contract to reflect whatever they truly intended. Never been tested on the bar exam, ever. What is always tested, every single exam, is unilateral error. That is where only one party is mistaken. And you'll remember from your law school days, no doubt, that courts always have problems in this area because they're trying to solve that basic dilemma of whether we should let a party out of a contract and frustrate the other's expectations or hold him to something that he obviously did not understand. So we balance the rights of the parties by using these 2 prongs at the bottom of page 7. That is, we only allow you out of an error in Louisiana if it concerns a cause without which the obligation would not have been incurred. And that's an error that I just noticed for the first time at the bottom of page 7. It says the error concerns the principal cause. That should be changed. It's the error concerns a but-for cause. It used to be a principal cause requirement. That is, the error was about something that is the most important reason that you entered into the contract. That's no longer a requirement. The requirement is that it be about a but-for cause. That is, some reason for which, if you had known the truth, you would have not entered into the contract. It doesn't have to be the biggest reason, but it has to be a big reason, a but-for reason. All right, so the error has to concern a cause without which the obligation would not have been incurred. And the second requirement is that the cause has to be known or should have been known, actual or constructive knowledge in the other party. If you're common law trained, you remember common law contracts the best, you're going to need to do some work here. This is different from the rule in common law contracts. In common law contracts, the requirement is that the error be known to the other party. That is not required in Louisiana. You need to say that. The only rule here is that your cause be known to the other party. So he doesn't have to know that you erred. He just has to know what your cause is. I'll show you some examples in a few moments. Those are the 2 requirements. You're going to be stating them and applying them every single exam. Top of page 8. There's a list of the types of mistakes that a court could find to meet the error requirements back on page 7, right? The list is at the top of page 8. It's merely illustrative, right? These are things that might meet those requirements at the bottom of page 7, but basically anything will do. So an error about the type of contract you're entering into. You think you're getting a donation, you're actually signing a settlement. Error about the identity of the other party to the contract. Take a look at number 5. It's pretty frequently tested on the bar. Error of law. That can be the basis of rescission for error for most types of contracts. For some contracts that we'll talk about specifically, we don't allow that, but in general, that's possible. So, for example, the bar exam tests this one frequently. You buy some property and your principal motive for doing so is that you want to turn it into a gas station, but you misunderstood the zoning laws and didn't realize that that was prohibited. That may be an error of law that you could use to allow you to get out of the sale. It's at least eligible for rescission. Now, you always have to meet those 2 requirements at the bottom of page 7, right? But error of law is a possibility anyway. All right, so a little bit more on those 2 requirements that I just mentioned. They're listed again in the middle of page 8. Be sure you understand that a contract will only be rescinded for error if the error bears on a but-for cause for entering into the contract. Remember, the point of that requirement is to make sure that people don't get out of contracts for trivial reasons, something that you didn't really care about. Needs to be something that you would not have gone ahead with the contract had you known the truth. Second requirement, again, is that the other party know of the cause, not of the error, but of the cause. And again, remember, the point of that is to ensure that the non-erring party is not totally taken off guard. The difficulty in these cases, and on the bar exam, of course, comes from the language of the requirement. That is, it's relatively easy to figure out whether the other party knew of your cause, but not so easy to figure out whether the other party, the non-erring party, should have known of your cause. And so on the bar exam, that's the tricky part, the should have known language. And that's where all the litigation, of course, takes place. And so what you need to remember, I suppose, about this is if the erring party told the other person of his cause, well, that's an easy case. It's not so easy when he doesn't say anything about his cause. And so the general principle here is that the more unique your wishes are, the more likely you're going to have a duty to communicate them directly. If it's obvious you're looking for a certain thing, you don't need to say that to create constructive knowledge. But if your wishes are especially idiosyncratic or unique, then you're probably going to have to convey something. So here's a question repeated multiple times on old bar exams on this issue that raises exactly this knowledge requirement. Two parties agree that one is going to provide to the other a certain number of oak trees planted on his property. The party that requested the trees wanted live oak trees and thought he was getting live oak trees. It's actually red oak trees that are planted. The contract says, I'm going to provide you 500 oak trees. So the examiner asks you to analyze whether the court should grant rescission for error. And the answer is probably not, maybe because the second prong is not met. That is, it would be hard to say that the other party should have known that a guy wanted a certain type of oak. I mean, why should you have known that he wanted a live oak instead of a red oak if he didn't say that? Right? So again, the more unique your wishes are, the more likely you have to say something specific about them. All the issue really comes down to that should have known requirement. All right, error. Absolutely know those principles. You will use it frequently. Second vice of consent that we're going to consider is fraud. Again, tested almost every exam along with error, in part because fraud is just induced error. So if the examiner has gone to the trouble of laying out the facts of error, he usually will go a step further and give you one additional fact that amounts to fraud as well. Memorize the definition. You will absolutely use it. It's either the misrepresentation or suppression of the truth with the intent of getting an unjust advantage or of causing a loss or inconvenience to the other party. So first thing you should remember again is that connection between fraud and error. Fraud is just induced error. But remember that it doesn't even have to be, usually it's a misrepresentation, but a suppression will do as well. Silence under some circumstances may be fraud. We'll talk about limitations on that in just a second. There's an exception here, very important, almost always tested when fraud is tested, and that is even if that definition of fraud is met, you can't rescind a contract for fraud if the truth was easily ascertainable. So here's the one the bar examiner has used several times. Guys entering into a sales contract for a car, face-to-face with the seller, and the seller says, I'm so excited about selling you this car, it only has 20,000 miles on it. But if the buyer were to look down at the odometer, he would notice that the odometer reads 45,000 miles. Under those circumstances, there's a fraud. Misrepresentation of the truth with intent to gain an unjust advantage, but we're not going to let anybody out of the contract for fraud because the truth would be easy to ascertain. If you don't exercise diligence in determining a fraud, then we won't allow you out of the contract. The other way that this comes up frequently on the bar exam is parties engage in some kind of written deal with a lie in it to sell property, let's assume. Again, buyer looks at the contract, fails to read the contract, just signs it anyway. Right? Examiner asks you, can you get out on fraud? Perhaps not, because the truth was easily ascertainable, right? You're not reading the contract, you're reading and questioning requires some diligence. There's an exception to the exception, though, also listed in B1. That is, you can still rescind for fraud, even if the truth was easily ascertainable, when there's a special relationship of confidence between the parties, such that you're not likely to question or investigate what you're being told. Right? So despite your ability to learn the truth easily, this relationship of confidence lures you into a sense of belief. Usually that's going to require some sort of fiduciary relationship between the parties. So I've never seen an example of it on the bar exam, right? It doesn't apply between buyer and seller, for instance, right? If you've got, trustee and beneficiary of a trust, maybe, right? But absent some fiduciary relationship, that exception to the exception is not likely to be met. All right, let's assume you can get past all those requirements. You meet the definition of fraud, misrepresentation, suppression of the truth, whatever. The truth wasn't easily ascertained, so you meet all those humps. Because fraud is induced error, to rescind for fraud, you don't have to meet that but-for cause requirement that we had in error. Rather, bottom of page 8, it is merely necessary that the fraud be about something important, something that substantially influenced your consent. Doesn't have to be a reason, without which you wouldn't have entered into the contract, but it's something that substantially influenced your decision. It was important to you. So distinction between the necessity of the importance of your cause in error and fraud. Know that. Again, on page 9, I just mentioned this. Inherent in that definition of fraud, the suppression of the truth part, is the idea that fraud doesn't have to be committed by an affirmative lie. Silence can be fraud as well. But again, that's a pretty harsh rule to say that you can just be totally silent and commit a fraud. So our jurisprudence has limited the rule to say that silence will only be fraud where there's a relationship between the parties that imposes a duty to speak up. And once again, that requires a fiduciary relationship. All right, so if I sell you a house, I never tell you that a murder occurred there, can you sue me for fraud? No, absent some for my suppression of the truth, in other words? No, absent some fiduciary relationship between the two of us. There is no fiduciary relationship between buyer and seller, right? We would need some relationship of confidence. Last thing on your outline on fraud deals with fraud committed by a third party. General rule is that the fraud needs to have been committed by a party to the contract for a party to the contract to get out. But a fraud committed even by a third party may sometimes be enough to vitiate consent. Take a look at the rule here. For example, my brother, to help me, comes to you because he knows that you're entering into a deal with me and lies to you. You want to purchase my house. My brother lies to you about something that's going on in the house. You engage in the contract with me. Can you get out for fraud? Fraud committed here by a third party? And the answer is it depends on the contracting party's knowledge. If the non-defrauded party knows nothing of it, nothing of the third party fraud, then the fraud does not vitiate the contract. But if a contracting party knows or should know, once again, actual or constructive knowledge of the misrepresentation by the third party, then yes, that will be a basis for annulling the contract. For fraud, some sort of knowledge in the non-defrauded contracting party is required. I want you to make yourself a little note here that this is totally different than the rule we're about to cover in a second in duress. Right? We'll talk about third-party duress in just a second. We vitiate consent there, and we don't care at all about whether there's any knowledge in a contracting party. For fraud, third-party fraud will only vitiate consent with this knowledge, actual or constructive knowledge. All right, know the stuff in the outline on fraud. Finally, the last vice of consent we're taking up is duress. This, again, tested every few years, not nearly as much as the other two. And usually, it's been in 1 or 2 essay questions in the last 10 years, but tested more frequently every few years in those multiple choice questions. So I would spend a little bit less time on it. When we're talking about duress as a vice of consent, remember we're talking about a situation in which a party's will is overpowered. He's forced into consenting when he does not want to. The code will allow you to get out of a contract for duress, but it's got several elements that we have to find before we'll nullify for duress. First, remember the conduct that constitutes duress has to be big enough to cause a reasonable fear of an unjust and considerable injury to your person, property, reputation, or to somebody that you love. All that focuses on the act of duress. So somebody has to make a threat of injury, and it has to be of considerable magnitude. All right, so let's think about that. This is right under the act of duress, that considerable magnitude idea. There's a question on the bar exam, it's been recycled at least 3 times in the last few years, in which a guy says to another, agree to this provision in a contract, or I'll have your dad barred from riding in this Mardi Gras parade that he likes to ride in. And so you're supposed to talk about whether you can vitiate for duress. And obviously the question is, right, is threatening you with not being able, or threatening your loved one with not being able to ride in a Mardi Gras parade a threat of considerable magnitude? I suppose we could differ in opinions on that. The bar examiner has a sense of humor. But there's obviously some question as to the magnitude issue, so you need to be discussing that, right? That's different than agree to this contract or I will shoot you, right? Obviously, we have considerable magnitude met there. Second, the person, or additionally, the person making the threat has to appear to have the ability to carry it out. And you have to reasonably fear that they will do this. And the injury the person threatens has to be unjust. The bar examiner likes to test on that, right? If you have a right to do what you threaten to do, that's not duress, right? It has to be an unjust injury. For example, if I threaten to sue you, right, enter into this contract with me that has these terms favorable to me, or I'm going to sue you. That may or may not be duress. It depends upon whether it's an unjust threat. If I have a cause of action against you, right, it's not a frivolous claim, then it's not duress, right? It has to be a threat of an unjust injury. As we discussed just a minute ago with regard to error, duress can vitiate a contract. This is number 3, if it's perpetrated by somebody other than the parties to the contract. And here again, it does not matter what the parties to the contract knew about the duress that a third party perpetrated. If the definition and all those requirements of duress are met, a contract will be set aside even if the duress is committed by a third party. Don't think about that actual or constructive knowledge requirement like you have to do for fraud. Finally, the recovery that you can get in duress, I'm at the top of page 10 now, is extremely important. The bar examiner has tested on this in contrast to error and fraud several times. In duress, again, we're rescinding the contract. We're kind of pretending it never existed at all, but we'll still allow the party, top of page 10, we'll still allow the party who was under the duress to recover damages and attorney's fees from the person who perpetrated the duress. All right, so know that remedy. Bar examiner tests on that remedy relatively frequently. Again, duress not nearly as important as error and fraud in terms of the payoff that you're likely to get, but tested frequently enough for you to know the basic rules. Next section on your outline, interpretation of contracts, page 10 and 11 is relatively new in the outline in the last couple years. I resisted putting it in forever. I hate it. I'm angry that it has to be in the outline. The only reason it's in here is that it was tested, interpretation of contracts, once on an essay question, but that's been a long time ago now. I think 2005 or so, and then one more time on a multiple choice question. That's it. I mean, in the history of the bar exam, those are the 2 times it's been tested. Nonetheless, putting it in there twice when you know nothing about it or haven't reviewed anything about it was sort of a bad thing. So anyway, it's in here now, but only tested twice ever and not in a long time. Last time was 2008. So I don't know. You make a decision about how much time you want to spend here. I think it's very low payoff and stupid rules that shouldn't be tested on the bar exam, which is why I don't like it. But anyway, you're not going to say that in response to your question. The good news, I suppose, is that the rules themselves are relatively simple. They're kind of statutory interpretation principles that you probably learned in some course along the way. The basic rule is that a contract, of course, is all about the party's intent. We're searching for their intent to ascertain the meaning of their agreement. And so you have this rule on the meaning of their words. If the words are clear, no matter how asinine it is, no matter how ridiculous it is, we don't go further in interpreting, right? Articulate that principle. If the words are clear, no interpretation is necessary. It's only if the party's words are ambiguous that we need to resort to principles of interpretation, principles of contractual interpretation. But again, they're very similar to those statutory interpretation principles. that you learned. In deciding whether the parties' words are clear, remember we are to afford their words their generally prevailing meaning, unless they are terms of art or technical terms. And if a word has, I'm in the middle of page 10, multiple common meanings, we always interpret the word in a way that upholds the contract. All right, see what I mean? I mean, there's silly little specific rules. Civil Code says, I'm on D1 now, that we read similar provisions in contracts in light of each other, in pari materia. We may make some assumptions from the degree of specificity of the language in a contract. So, a generally worded contract should be read only to include general things. We shouldn't import specificity where the parties don't use it. If none of that works, then look at the top of page 11, bottom of page 10 on to page 11. Equitable aids to interpretation may help. So usages of the parties, industry practice, other contracts between the parties. Finally, I'm on number 4. We interpret contracts against their drafter. I'm not going through every one in detail because it's just not even possible that you could be called upon to apply all these. So I'm giving you the most important stuff. Number 4, we interpret, this one I would know, we interpret contracts generally against their drafter. Now, that's only relevant if the contract is in one party's standard form, right? Or one party drafted the contract. It wasn't a mutual effort here. Interpret it against its drafter. And because the obligor usually has less bargaining power, we generally interpret contracts in his favor and against the obligee. But, now you see why I think these rules are so dumb, if an ambiguity results from an obligor's fault, or his failure to explain something in the contract, then we interpret the contract in a manner favorable to the obligee. So, I mean, the rules are just so inconsistent. Anyway, I guess I'd memorize the basic ones about generally prevailing meanings versus technical meanings, in pari materia, and interpret against the drafter. Knowing that, I think, will be sufficient. If you can memorize it all, wonderful. But that's where I would put the biggest payoff into. Again, tested only twice, ever, and it's been a long time, but we never exactly know what's coming, so they're here. Bottom of page 11, we have been talking about the vices of consent, right? Absent this little foray into interpretation of contracts, we've been talking about the vices of consent, whether we'll interpret a contract so as to uphold it. All of this has been working us toward a discussion of nullity. Because remember, if any of those 4 requirements of contract, capacity, cause, consent, or object is missing, you've got a nullity. If any of the vices of consent are present, error, fraud, duress, you've got a nullity. I mentioned to you a little while ago that there are 2 types of nullity in Louisiana. This is tested almost every single bar exam. Absolute versus relative nullity. Any work you put in to know all of these distinctions, and luckily there aren't many, will definitely pay off. So recall first that an absolutely null contract is defined as one in Louisiana that violates a rule of public order. So if the object or the cause of a contract is illegal, for instance, that's an absolute nullity. And there are 3 characteristics of absolute nullity that make it important and that distinguish it from relative nullity. Bar examiner is testing you on every single one every time he tests this stuff, so know them all. First, an absolutely null contract cannot be confirmed. You'll recall confirmation is similar to ratification. It's when, after the fact, you agree to be bound by some contract that had some kind of defect. It's impossible to confirm or ratify an absolute nullity. Second, anyone, including the court, can invoke absolute nullity. We don't require the parties to bring it up. The court can do that on its own. And third, an action to recognize an absolute nullity is imprescriptible. There is no liberative prescription on it. You'll remember yesterday when we talked liberative prescription, we said that parties can't, by contract, make a scenario imprescriptible, but the legislature can, and here's one in which they've done so. Absolute nullities, imprescriptible. A relative nullity, on the other hand, is not one that violates a rule of public order. Rather, it violates a rule intended to protect a private party. So top of page 12, rules of capacity, for instance, are supposed to protect the minor, the interdict, the PDR, right? Not the public in general. Obviously, there's some public policy behind it, but these are relative nullities. Who cares? Well, relative nullities can be confirmed. Examiner tests you on this frequently. So once the minor comes of age, for instance, He can go back and confirm or ratify all the contracts that he did during minority. I enter into a bunch of contracts when I'm drunk. Once I sober up, I can go back and confirm the nullity in all of those contracts. Same thing goes for an interdict, if the interdiction is ever listed. Secondly, in contrast to an absolute nullity, a relative nullity can only be invoked by the party in whose favor it exists. This was back over there in the capacity section of the outline too. I mentioned it there, but one more time. If a minor buys a car from a car dealer, the car dealer decides better of it and wants to rescind. Too bad. Only the minor can rescind. I'm drunk and I buy a car from a car dealer. The car dealer decides better of it, got a bad deal with a drunk person, and wants to rescind. Too bad. Only the drunk person can rescind. Relative nullity can only be asserted by the party in whose interests it exists. And finally, the examiner likes to test this. There's a liberative prescription on actions to assert a relative nullity. It's not the 10-year default for contracts. Rather, here there's a special 5-year period. That's the easy part. Memorize it, 5 years. The difficult part is, when does the 5 years begin to run? And unfortunately, there are two different rules here. Depends on the cause of the nullity. So it's 5 years either from the time the ground for nullity ceases or 5 years from discovery. So which is which? In the case of duress, the problem was always known. Same thing with capacity, right? Like the kid's a minor, he just is. And so for both of those, the 5 years begins to run from when the problem ceases. So when the kid becomes a major, or in the case of duress, when the duress lifts. In the case of error or fraud, on the other hand, it may take a while before the party learns of them, and so the 5 years begins to run from the date the error or fraud was discovered. Remember, here's what's tested on the bar exam, that could conceivably be 20 years after the contract was signed. So it's a 5-year prescription, but not from the date of the contract. For error or fraud, 5 years from discovery. For duress or capacity, 5 years from the date that the ground for nullity ceases. Finally, you should know the effects of nullity on page 12. If it's successfully invoked, then the contract, remember, is deemed never to have existed, unless it's confirmed or something like that. What do we mean by that? Well, when we say it's deemed never to have existed, that means that any performance that's been rendered has to be returned. But don't forget, right, you've reviewed this in 50,000 other places. I'm going to keep beating the horse here. Nullity cannot affect rights that third parties have acquired. Right? So if we're talking about immovables, the public records doctrine gives third parties certain rights, and so yes, we annul and put everybody back in the position that we can, to the extent the public records doctrine doesn't prohibit that. Right? So for immovables, you have the public records doctrine. Even for movable property, you reviewed principles in the property course saying that if we have third parties who acquired onerously in good faith, we may not disturb their rights. So general principle, we undo and put everybody back as though it never happened. Third parties may be protected by other doctrines of the law. Don't forget that. Next thing we need to talk about is the effects of contracts. And many of these things, at least to start, until we get to damages or breach, will sound very familiar because we've reviewed them in the context of obligations. Again, contracts are just a specific type of obligation, a subset of obligation, so we can be quick on the start of them anyway. Look at A in the middle of page 12. Contracts are the law between the parties, so they are binding on the parties, can only be dissolved if the parties agree to that, or the law says so. We already talked about that. Contracts don't generally bind people that are not parties to them. Now, we just talked about some exceptions to that. All right, third-party beneficiary, we bring someone into the contract that wasn't a party. Premise to port 4, we may bind someone that wasn't a party. So there are exceptions, but that's the general rule. There's a good faith requirement imposed on all parties to contracts. We talked about this yesterday in obligations. No shocker that it's restated specifically in contracts. Just like all obligations, C, we talked about this, contracts are heritable. Obligations are heritable, contracts are heritable. Don't forget, heritable means transferable during life as well. Contractual breach, D, is something new that we need to review. Remember, the term Louisiana's code uses isn't really breach, it's failure to perform. but it's the same thing. Our courts use them interchangeably, and you use a judgment call on what to do on the bar exam. I think it'd be fine to call it breach. Try, if you can recall, to call it failure to perform. That's the codal language. You'll know that you're a good civilian. Breach or failure to perform means one of three things. It could be non-performance. You do nothing. Defective performance, that is, you render performance, but something's wrong with it, doesn't conform. Or it could be delayed performance, that is, the performance is conforming and appropriate, but it's later than it was due. All three of those are treated as breach under Louisiana law, so you can apply all the rules that follow on breach. All right, so if you have any of those breaches, what happens? Well, you'll remember from our obligations review yesterday that an obligor's failure to perform might be excused if there's impossibility of performance because of some fortuitous event. But absent impossibility or something like that, right? Remember, you're going to apply all these obligations rules and contracts principles together. But absent impossibility, a failure to perform gives rise to damages for the aggrieved obligee, whatever damages are caused by the breach. And in addition to those damages, that's the important part, in addition to those damages, the obligee has to elect remedies, top of page 13. And electing remedies means you have to choose between one of two things: specific performance by the breaching obligor or dissolution. You can seek both in the alternative, or you can ask for one, but no matter what you do, you're only going to get one. Right? But don't forget, you get damages and your choice of election of remedies, right? Easy to forget, but you get both. Damages plus either specific performance or dissolution. Now, if you choose specific performance, your damages are limited. The only damages you're going to get are delay damages, moratory damages, which we'll be reviewing in just a minute. If you choose dissolution, you're going to get more damages, compensatories, to substitute for performance. All right, so let's talk about those two remedies in more detail, and we will start with specific performance. So first, unlike the common law, you need to remember and say on the bar exam in Louisiana that Louisiana has, if not a preference for specific performance, then at least a receptiveness to it that common law jurisdictions do not have. We like it, we'll grant it a lot more frequently than other states do. There are a couple of requirements you have to meet to get it. But generally it can be requested. So you'll see here it's easier to get if the contract that's breached involves an obligation of one of three types. That is, a duty to deliver a thing, a duty to not do an act, to refrain from doing an act, or a duty to execute an instrument. And you'll remember that's because specific performance is forcing something to happen. So if all you had to do was sign an instrument, well, we can make you do that. Or if you refuse, just do it for you. Right? What's obviously missing from that list, and where we don't as frequently grant specific performance, is for a duty to do something. That is, a duty to engage in affirmative activity. Right? So it's hard for a court to force me to paint a picture, force me to build a house I promised to build. So specific performance is not generally given for a duty to do. But again, these are just preferences. The court has discretion. They're not prohibitions or anything. Even if you have one of the types of duties here, duty to deliver, not do, execute an instrument, all that means is that you're more likely to get specific performance, but the remedy is not automatic. It has to be practicable. If it would be impracticable to grant specific performance, a court won't do it. And the leading case on this is the Weingarten case listed here. You know why you have the facts, because the bar examiner has tested it using these exact facts. So the facts of Weingarten were this: lessee in a shopping center lease was guaranteed a certain number of parking places. Lessor breached that agreement by building an expansion that took over a bunch of the parking lot. Lessee sues and asks for specific performance, saying it was a duty not to do, duty not to obstruct the parking, and the lessor obstructed the parking. Lessee wants the portion of the addition torn down. So the court agreed that this was a duty not to do, and that generally specific performance would be permissible, but the Louisiana Supreme Court refused to order specific performance here because it said this would be economic waste. Right? I mean, to enforce specific performance, tear down a portion of this shopping center is just absurd for a few parking spaces. So it's not an absolute guarantee that you'll get specific performance if it's one of these favored duties. If it's impracticable, such as tearing down portions of shopping centers, won't be awarded. Likewise, number 2 at the bottom of the page, if the duty is a duty to do, again, to engage in affirmative activity, specific performance is harder to get. Doesn't mean it's impossible, just harder. Court has discretion. All right, that's it for specific performance. Damages, again, is the remedy that you get whether you choose dissolution or specific performance. So anytime there's a failure to perform that's unexcused, the obligor is liable for damages. It may be confusing to you. Go back up to the top of page 13. I'm talking about your election of remedies between 2 different things, specific performance and dissolution. I've just done specific performance. Hold off for a second. I'm not doing dissolution yet. I'm putting damages in the middle because you get damages for each. All right, so damages now. Let's talk about your entitlement to damages. We measure damages with 2 elements in Louisiana. You will be called upon to apply these. It's at the very bottom of page 13. The loss that the obligee sustains and the profit of which he's been deprived. That's the general rule, at least. Remember, there are areas in which we depart from that. Detrimental reliance, of course, is one. You only get your expenses back. But generally, loss you've sustained, profit of which you've been deprived. Top of page 14, the obligor's liability for those damages, though, is affected by whether his breach was a good faith breach or a bad faith breach. All right, obviously he has to pay more if he's bad. So if the breach was done by the obligor in good faith, meaning it was innocent, not malicious, oops, accidental, then the obligor is liable only for damages that were reasonably foreseeable at the time the contract was made. If, on the other hand, the breach is in bad faith, intentional, meant to harm, then the damages are not limited to reasonable foreseeability. Rather, any damages can be awarded as long as they're a direct consequence of the breach. You'll remember, bad faith in this context, maliciousness is pretty hard to find. It's not typically going to be the case. Courts aren't likely to say that's present very often, so you're likely going to be applying the good faith rule. All this good faith, bad faith stuff at the beginning is what the obligor can do to affect the damages that he's required to pay. The obligee can also do some things that will affect his ability to get damages. If the obligee's own misconduct, his own bad faith, causes the breach, or if he conceals facts that he knows or should know at the time of contracting will cause a failure to perform, then he can't recover damages. Likewise, the obligee can have his recoverable damages reduced if he's been negligent. And finally, and the only one that I've seen tested of these 3, is the duty to mitigate. Tested relatively frequently. That's all the code says, that the obligee has a duty to mitigate his damages. But the case law makes the duty pretty specific. You've got the seminal Louisiana Supreme Court case cited here. It sets out 2 requirements for the obligee's duty to mitigate. The test is that in order for you to be required to mitigate, the price it would have cost to mitigate damages would have been very small in comparison to the extreme losses that would result otherwise. So small price of mitigation as opposed to extreme losses, number 1. And number 2, it's virtually certain that mitigating would have avoided at least some loss. All right, so small cost of mitigation, virtual certainty of the avoidance of some loss. In the case cited here, the examiner has used at least 3 times in recent years. It involved, you may remember this one, a pool that developed a bunch of cracks. And the obligor sued for it, obligee sues for it. Obligor tries to shift some blame to the obligee, saying that if the obligee would have filled in the cracks as soon as they started to appear, right, total disaster wouldn't have occurred. It would have avoided some of the loss. Louisiana Supreme Court said, no way. Would have cost tons of money to fill in these little cracks, and there's not even a certainty that that would have fixed the problem, right? Cracks developed all over this pool. So no duty to mitigate where the test is not met. Need a small cost of mitigating, virtual certainty of avoidance of loss. The availability of non-pecuniary damages is tested probably every 2 or 3 years, so take a look at the rules on that. Generally, you'll remember damages for breach of contract are compensatories, meaning they do not include non-compensatories like pain and suffering. You might get that stuff in tort, but generally not in contract. However, that's just the general rule. Non-pecuniaries may be available for a breach of contract under 2 circumstances, 2 and only 2. First, if a contract has some non-pecuniary link and the obligor knows or should have known that if he breaches, it's going to cause emotional distress, a non-pecuniary loss, the non-pecuniaries will be available. So here's the case that the bar examiner has tested those 2 or 3 times that he's tested it. It's based on this Ford case cited at the bottom of page 14. Guy buys a Ford truck and it has a defect, so he sues obviously for the defect in the truck, but in addition to other damages, he wants damages for the pain and suffering of having this defective Ford truck that really stressed him out and traumatized him. And the court said in that case, no, he cannot get non-pecuniaries for the sales contract because you need the nature of the contract to be at least somewhat non-pecuniary. And here it wasn't, particularly because in this case, and that's what's been used on the bar exam, the guy bought the truck for his business as a service vehicle. Right, so there's no emotional component, no non-pecuniary component to that. If there is, and the other party knew of the emotional component, may be non-pecuniaries. That's one situation in which you'll get non-pecuniaries. Second situation, bottom of that long paragraph, in which you'll get non-pecuniaries is when the obligor intentionally breaches, intentionally hurts the obligee's feelings, knowing that he will leave him this way. That one I've never seen tested on the bar. If one of those is met, non-pecuniaries will be recoverable. Otherwise, no. Obviously, know the general rule and then be prepared for that contract to gratify a non-pecuniary interest. Second way that parties can modify the damage provisions, it's possible for parties to, bottom of page 14, contractually modify the damage provisions that are set out in the civil code. And there are 2 ways that you're allowed to do that, right? That is, we just talked about what damages you can get, loss that you sustain, profit of which you're deprived, 2 ways that you can do it. First, the contract can address damages and it can allocate risk. So for example, the parties can exclude the damages provided for in the civil code, general freedom to contract on this issue. However, bottom of page 14, there are some exceptions, public policy exceptions that you cannot contract around. First of all, you probably covered these in torts as well. Or you haven't done torts yet, have you? Have you done torts? Yeah, okay, good. So you'll remember then that you cannot exclude or limit liability for intentional or gross fault. We don't permit you for public policy reasons to do that by contract. And you cannot exclude or limit liability for causing physical injury. As long as you don't run afoul of that, you can exclude or modify damage provisions in whatever way you want, basically. So that's one way. Parties can contract around it. Just do it by contract without running afoul of those limitations. Second way, parties can modify damage provisions in sort of a different way is to contractually provide for stipulated damages, top of page 15. In the common law, we would call this liquidated damages. You're going to call them stipulated damages. And you'll remember that this is where the parties decide in advance what the obligor's responsibility will be in the case of breach. In principle, that's perfectly permissible. You can stipulate damages. It's great. We like it, right? Because the purpose is to obviate the need for the obligee to prove up damages. So it saves time. All the obligee has to do is show a breach by the obligor, and then he can receive the stipulated damages. Doesn't have to prove them up. But there are some caveats here that you need to remember. First, stipulated damages are not going to be recoverable, not enforceable, if they're totally out of line with the actual damages that you would have received. And remember, the reason for that is that damages in contract are supposed to be compensatory, not punitive. So if your stipulated damages are too high, we think they look punitive, we'll strike them down. So stipulated damages may be too high and struck down as punitive, otherwise perfectly permissible to do. And be sure also that you realize that stipulated damages are the result of breach. So if the obligor has not performed, but he's got some excuse, impossibility, for instance, then he's not liable for stipulated damages. Those are the only 2 caveats. That it has to be an obligor who is actually liable. He's not relieved of responsibility, and then they need to be in line with the compensatory damages that would otherwise be awarded. Finally, with regard to damages, you need to know about moratory damages, which I just mentioned a few moments ago, or delay damages. These are just normal damages too. They're only separated out. They're distinct in your outline because you can get these damages even if you seek specific performance. Indeed, these are the only damages you can get if you choose to seek specific performance. We're all on the same page, right? They're also available if you choose dissolution, but they're broken out here separately because it's the only thing you can get in the way of damages if you seek specific performance. And there's some special rules for the recovery of moratory damages. Specifically, they are only owed from the time the obligor is put in default. So you need to recall the rules on so-called putting in default. You'll remember that in most cases of breach, the obligor is automatically in default. So when you've got a contract with a term that's either fixed or clearly determined, the arrival of that term automatically puts the obligor in default. If the obligee hasn't promised performance at a certain time, though, it's not a term contract, he can't hold the obligor for delayed damages unless he takes affirmative action to put him in default, because it's not clear that the obligor should have performed yet. So to do that, to put him in default, obligee needs to say, the time for performance has arrived. I will hold you accountable for damages if you don't perform by X day. Right, the point is that the need for the obligee to put the obligor in default to get moratory damages is only applicable when it is not clear that he was already supposed to perform. If you have to put the obligor in default, if that's necessary, the way that you do it is either to make a written demand for performance, make an oral demand in front of 2 witnesses, or sue for specific performance. The only thing that's not good enough, is filing suit for dissolution. Because when you file suit for dissolution, you're telling the obligor that you want him to perform. Right? So do one of these 3 things, but dissolution doesn't do it. And of course, if there's a provision in the party's contract that says that putting in default is automatic, we'll go with that. Of course, you can always contract around all of these rules except the ones that violate public policy. Dissolution is the other remedy. Let me get through dissolution before we take our last break. Dissolution is the other remedy that can be elected in lieu of specific performance. And when you're seeking dissolution, remember you're trying to cancel the contract. Do not confuse this on the exam with the term rescission, which is the term we use when there's a nullity. I know the bar examiners go crazy, or the graders go crazy with this. So dissolution is for breach. Right? Rescission is for nullity. Use the correct word here. You have a valid contract, it's breached, the obligee asks the court to set it aside, that's dissolution. The obligee that elects the remedy of dissolution rather than specific performance can ask, look down at your outline broadly, for either extrajudicial dissolution or at the bottom, judicial dissolution. So think broadly first before we start the specifics of extrajudicial dissolution. The primary difference between the two is that the obligee that qualifies for extrajudicial dissolution is ensured that he's going to get it. In other words, the judge, if you qualify for extrajudicial dissolution, the judge can't grant you specific performance, defying your wishes. If, on the other hand, you don't qualify for extrajudicial dissolution and you have to go with judicial dissolution, you might get it if you're lucky, but the court also might choose to defy you and grant specific performance instead. So that's why we care. All right, so now let's go back up to extrajudicial dissolution. It's important to qualify because if you get it, then if you qualify, then you'll definitely get dissolution instead of specific performance. So when do you qualify? Well, it's a slam dunk under A where you have an express dissolution clause. So if the contract says under X circumstances, somebody can seek extrajudicial dissolution, great. We'll go with that. If there's no such provision in a contract, Part B, an obligee on any contract can ensure his entitlement to extrajudicial dissolution by following these steps. First, he has to give notice to the obligor that he wants performance within some reasonable time. It's kind of like the putting in default. The obligee needs to tell the obligor in the notice that he's going to consider the contract dissolved if the obligor doesn't comply within this reasonable time set out for performance. And if the obligee does this and he makes sure that the notice is in the form required for putting someone in default, which remember is either in writing or orally in front of 2 witnesses, he can consider the contract dissolved. All right, that's dissolution after notice to perform. One more way, this is C, really 2 ways sandwiched into one here, that a party can guarantee his right to extrajudicial dissolution. On your outline, it's called dissolution without notice to perform. There are really 2 possibilities. The first is that you can seek extrajudicial dissolution when it's evident that the obligor is not going to perform. You may recall that dubbed the active breach. So the obligor basically tells you, yeah, I'm not going to perform under that contract. The aggrieved obligee in this scenario has the right to ask for specific performance if he wants, but he could also assert a right to have the contract dissolved extrajudicially, which he may frequently do so he can go contract with somebody else. So if it's evident that the other party is not going to perform, dissolution extrajudicially. Or the second possibility that's encapsulated under that C is that a party can get judicial dissolution, extrajudicial dissolution, when the contract is one in which delayed performance would be of no value to him. You may recall this as referred to as a contract where time is of the essence. Right? So, for example, I'm a merchant of Christmas ornaments, and I order from you ornaments to be delivered to me on November 1st, and on December 23rd, they still haven't come. I can assert my right to extrajudicial dissolution because it's not going to be of any value to me to get them on December 24th. Right? Time is of the essence. Those are the ways to qualify for extrajudicial dissolution. Now, don't be confused on the exam. Qualifying for extrajudicial dissolution doesn't mean that you don't go to court. You still do, because remember, you can seek damages too. So you're going to ask for dissolution extrajudicially out of court, but you may have to go to court to get your damages. That's fine. The advantage of extrajudicial dissolution is that it deprives the court of discretion to order specific performance. If you do not qualify in any of those ways that we just discussed, then you're stuck, bottom of page 15, with judicial dissolution. And right, one more time beating the horse. The bad part is that if you're stuck there, you might get it if you're lucky, but the court might also order specific performance, even if that's not what you want. So you always want to qualify for extrajudicial dissolution if you can. All right, let's suppose that we have dissolution in some way, doesn't matter, judicial or extrajudicial, top of page 16. What are the effects? You need to know this. When a contract is dissolved, just like rescission, the parties are put back in their original position. Just like for rescission, for nullity, there may be third party or doctrines of the law that don't allow us to do that with respect to third parties. So the public records doctrine inhibits our ability to take immovables away from third parties that relied. The good faith purchaser doctrine, onerous purchases of good faith movables may affect matters as well here. But generally, we put everybody back in the position that they would have been in otherwise. And finally, number 4 at the top of page 16, it's possible that dissolution can be denied even if you are otherwise entitled to it if there's already been performance of a substantial part of the contract. And there's still a breach because it hasn't been fully performed, right? But the unperformed part is not that significant. Under those circumstances, the court may grant damages for the difference or grant specific performance rather than dissolving the contract. That leaves us with just a few little loose ends on contracts, and then we have that relatively short outline on mandate. So I'll give you one last break, 10 minutes, and then come back and we'll finish it off. Ready? All right, let's finish it off. We have just a couple of loose ends to tie up on contracts. We're at the middle of page 16. Next thing we need to talk about is a simulation. I mentioned a simulation, or at least one of the two types of simulation to you a little while ago. A simulation, remember, is the term that we use in Louisiana to describe a contract in which the parties do not express their true intent. So they lie about their cause. Remember when we were discussing cause a little while ago, we said, first of all, that this is okay. It's not required that you express your cause at all. And if you lie about your cause, that's cool in Louisiana too. Not necessarily anything wrong with it. But there are two different types of simulations, and they have different effects. So now you need to recall that there's the absolute simulation and the relative simulation. Bar examiner relatively frequently asks you for just black letter regurgitation of what the two are and what the effects of them are. So be able to spit out what's here. The absolute simulation is when the parties, by mutual agreement, don't intend that their contract produce any real effects at all. So, for instance, I promise to sell you a piece of property because I don't want it to appear in my patrimony for whatever reasons, but I don't actually intend to transfer possession of the property to you, and neither one of us intend that you pay me any money. We don't intend that our contract have any real effect at all. Absolute simulations are not in and of themselves illegal or against public policy. They don't have any effects between the parties because the parties didn't intend any effects, but they can have effects as to third parties. So even an absolute simulation over immovable property, for instance, in that example I just gave you, may produce effects for third parties as long as it's recorded. So in my example, if we record this sham contract that we've made, which we don't intend to have any effect, a third party who purchases will be protected under the public records doctrine. Sometimes parties that engage, shake it up all over everybody. Sometimes parties that engage in simulations will express their real intentions in another writing later, usually called a counter letter. But again, whether the counter letter has any effect may depend on the public records doctrine. If the counter letter is not recorded, then that simulation won't prevent a third party from acquiring. That's the absolute simulation. The relative simulation, you'll recall, is much more common. In a relative simulation, the parties do intend that their contract have some effects, it's just not the ones they said. So the most common example here is the so-called simulated sale. It's that example I showed you a while ago in cause. My favorite child and I enter into a transaction which purports to be a sale of my property to child, well, major, let's assume he's a major, but I don't actually intend that my child pay me any price. We're calling it a sale, right? It's intended to have consequences to transfer ownership, but we intend our true cause is a donation. Relative simulation. So unlike in the absolute simulation, in a relative simulation, the parties intend effects, but just different ones from the ones they recite. So the important thing that you need to remember here, once again, is that these can produce effects even between the parties if they satisfy the requirements of the intended contract. So for example, that simulated sale that I just gave you the example of would be sufficient as long as we meet the form requirements to donate immovable property, which would be an authentic act. Right? Relative simulation can be valid. And same thing with regard to the public records doctrine. Just like an absolute simulation with respect to third parties, they may have effect if recorded in accordance with the public records doctrine. Bottom of page 16, there's a tiny snippet on page 16 and on to page 17 on the revocatory and oblique actions. These have only ever been tested one time on a multiple choice question, so relatively low payoff for you, but fair game. So I think it's enough for you to just know what it is, know what they are, not much else. We were talking before about how contracts generally produce effects only for the parties to them. Third parties are only affected under exceptional scenarios. This is one of them. Overall, the revocatory and oblique actions together involve a creditor of the obligor injecting himself into the obligor's contractual relationships and then complaining about what the obligor has done or not done. Right? That's how they're similar. Here's how they're different. In the revocatory action, the creditor is complaining about something that the obligor has done. right? I'm using creditor here instead of obligee because it's two different obligees. So in a revocatory action, the creditor is complaining about something the obligor has done. Creditor asserting a revocatory action is trying to revoke or annul a contract that the obligor has entered into. So you need to remember the requirements here. It's a harsh remedy to allow you to undo a contract you're not even a party to. So the contract the creditor seeks to revoke has to be one that causes or increases the insolvency of the obligor. Right, so my debtor, somebody owes me $5,000 and he sells off all his assets for a very low price to prevent me from getting them. I can use the revocatory action to sue the third party to whom he sold everything and get it back. Revoke the transaction. One more requirement that you need to know about, and that is that the act the creditor is trying to revoke has to have come about after the creditor's right arose. In other words, you're trying to undo some transaction that violated your vested right. Right? If you're trying to undo a transaction that came before you ever came along, you didn't have any rights then. Oblique action is very similar, but here a creditor is trying to step in to force the obligor to assert some heritable right that the obligor won't assert, which causes or increases his insolvency. For the creditor to be able to step in and assert the right, it has to be a heritable right, not a strictly personal one. Most common example is the right of a victim to bring a tort suit. That's a heritable right, right? So you owe me $5,000 on a debt and then you're run over in the parking lot today. You could sue that person and get the money to pay me, but you refuse to sue. I can assert the oblique action to force you to assert that right. Last thing, again, very, very, very infrequently tested. I just know what they are and say that's sufficient. Last thing we need to talk about in the contracts outline on contracts in general, you have, beginning on page 18, some special contracts, but on contracts in general, it's conflicts. Conflicts of law. We talked about conflicts of law yesterday. You'll recall when we were hitting liberative prescription. Again, it's tested across the bar exam on all parts now. But I'd be willing to bet money that if you see it on Code 3, and we're always nervous that our turn is coming around, that this is where it will be. It's likely not to be on liberative prescription, but conflicts in the context of contracts. So the examiner would likely give you a contract with a choice of law provision. It's been 4 or 5 years since this has been tested, but again, you'll recall conflicts was hit hard on community property and torts in recent years, so it's about our turn, I think. First, some background on the general scheme of conflicts, which we already sort of reviewed yesterday. You'll remember this. We follow the modern approach of contracts theory, not the restatement, meaning our approach is a comparative impairment one. We apply the substantive law of the state whose policies would be most seriously impaired if they were not applied. I won't belabor that because I know you've reviewed it in all your other sections as well. Well, in the contracts context, how do you determine which state's policies would be most seriously impaired if not applied? Obviously, you need a contract involving contacts with more than one state, and then you look at the degree of harm that would result from non-application of that state's rules. How do you determine the degree of harm? Well, it depends on the strength and relevance, strength and pertinence of each state's policies. If I give you the example that's always used on the bar exam for conflicts, you'll get this pretty easily. I reminded you of a little while ago in a different context, it's non-compete agreements. Remember before when we were talking about object of a contract, I said that Louisiana allows non-competes, but we're pretty strict about them. They have to be narrow, very narrow in Louisiana because they prevent parties from earning a living. We'll invalidate them more easily than other states will. Other states don't have such narrow policies. Texas, for instance, pretty freely allows non-competes. Right? So if you look at the facts, you have a non-compete agreement. There are contracts signed in Louisiana, but there are Texas connections as well. Right? You look at the policy behind the statute and see which state's policies would be most seriously impaired. If Louisiana has a strong policy against broad non-competes, then the answer would likely be Louisiana, even though our contract may have some connection to Texas as well. There's a list of things that you look at to determine which state's policies would be most seriously impaired on page 17. It's just illustrative. Don't memorize it. You got enough things you got to memorize. It's an extremely fact-intensive determination, but you're looking at the context of each party, the nature, the type, the purpose of the contract. Just look at it and get an idea of what you want to look for. Don't spend time memorizing that because the rule is the comparative impairment approach. You're just looking at these two things to inform your analysis of comparative impairment. That's the general rule. If you have a contract and you're deciding which law to apply, you look to see which jurisdiction's policies would be most seriously impaired if not applied. At the bottom of page 17, there are some special rules, though, on conflicts for particular issues involving contractual relationships. And when conflicts on contracts is tested, this is usually what it is, these special rules. So take a look at that. And let's take the issue of form, for example. Obviously, state law varies substantially on questions like whether you need a writing for certain types of contracts, whether you have to have witnesses, whatnot. And the rule on conflicts for form issues is very generous. It's designed to uphold as many contracts as possible. It's called, in conflicts jargon, a rule of validation. And so the rule, take a look here, is that a contract will be valid in form as long as it meets the form requirement of any of the states listed here, the state of making, performance, common domicile, or the state governing the substance. A rule of validation. You meet any of those form requirements, you're good under conflicts theory. Again, the idea is we're trying really hard to uphold contracts and not to strike them for differing states' form rules. There's one exception here. Of course, it's at the very bottom of the page, always this exception, right? And unless, and that is, we'll uphold the contract if it meets the form requirement of any of these states unless there's a public policy behind a particular form's form requirement that has been breached. So uphold if it meets any of these states' rules unless that's against public policy. All right, top of page 18. What if you have two states with a connection to the contract at issue and their rules of capacity differ? Right, the other state has a narrower conception of who's a PDR than ours does, for instance. What do? Well, we don't exactly have a rule of validation for capacity, but the rule limits the states that can have a say on capacity. Right? It's considered to be something best judged by a state with an intimate connection to the parties because it's about your mental capacity. Right? So the rule on conflicts on capacity is that capacity can be determined only by the state of domicile of the party at the time he makes the contract or by the state whose law is applicable to the substance of the contract, which of course you'll decide using the comparative impairment rule that we talked about at the beginning. So this capacity rule narrows down the possibilities to two. It's not a rule of validation, right? But at least there are two possibilities. If you meet the capacity requirement of either of those two states, you're good. Finally, know this, star it, highlight it, or whatever. There's a special rule on party autonomy. This is one of the special rules that the bar examiner likes to test on the most. When conflicts is tested, this is usually there. Party autonomy is talking about choice of law clauses in contracts. Parties, of course, very often include choice of law contracts, choice of law provisions in their contracts these days, which say what substantive law will apply to their contract. The overarching rule in the United States in general is that this is perfectly permissible. If you live in Mississippi and you want to be governed by French law or Alaskan law, whatever, that's totally fine. Louisiana subscribes to that policy and takes it even to greater lengths. Most other U.S. states require that the law you choose in your choice of law clause have some connection or nexus to the parties. No such requirement in Louisiana. So we will respect a choice of law clause even if you choose, right, Zimbabwean law and that has absolutely no connection to the parties or to the contract at all. That's fine in Louisiana. Freedom of choice here. Now, there's only one limitation, of course, that is we will not honor a choice of law clause if the law that you've chosen contravenes the public policy of a state whose substantive law would otherwise be applicable. And once again, on the exam, the only way that ever has come up is in the case of a non-compete agreement. So on one of the old exams, there's a non-compete agreement where a Louisiana resident agrees to sell some products manufactured in Texas here in Louisiana. So Texas manufacturer writes the contract and includes this choice of law clause regulating the contract under Texas law, which is, again, generally more accepting of non-competes than we are. That would be a problem, because usually we'll respect the choice of law clause, but we have a Louisiana resident selling things in Louisiana. The Louisiana policy is pretty strongly against broad non-compete, so that exception for public policy may be implicated here. Normally, we go with the choice of law, not if it violates public policy. All right, we can sort of put a pin in it there. That is, I guess I would stop or make a big line for yourself between everything that's come before and everything that comes after. Everything else that remains in the contracts outline is referred to as special types of contracts. These used to be all last year in a separate outline called miscellaneous Code 3 topics. I guess they're better placed here because they are all contracts, but I'm saying something about it. It bothers me that they are here because it kind of implicates that everything else in the outline has the same importance of what comes before, and that's definitely not true. I'll explain to you why in just a second. With the exception of these last little paragraph C on page 20 for compromise, I'd circle that, star it, highlight it, whatever. Know that. Everything else, though, from pages 18 to 20, I'm going to go over super briefly. I think you should read it right now and think about it while I'm talking, and then don't ever waste your time with it again, because it's just not heavily tested. I'll tell you why it's in the outline at all in just a second. All right, so let's start. That's not true of compromise. You do need to know compromise. Miscellaneous contracts that don't really fall into, they're nominate contracts that don't fall into anything that we've discussed before but have special rules. The first one listed in your outline, or the first two listed in your outline, are deposit and sequestration. And this has been sort of an interesting, from my perspective, contract over the years to figure out what the heck to do with in the bar review, because until the year 2005, deposit was listed by the bar committee as on the potential topics to be tested on Code 3, but there had never been a deposit question in the history of the bar exam. And then in February of 2005, we had sort of the perfect storm for a question on deposit. That's when we got a new examiner, the guy that just finished up, so he had been the examiner for 10 years. And the legislature approved a total revision of all the deposit rules in the Civil Code that was effective in 2004, testable for the first time in February 2005. And so unfortunately, what happened is that on the February 2005 exam, the bar examiner hit deposit, and hit deposit really hard. He tested literally every single one of these rules in the entirety of the outline, and nobody knew what the hell was going on because nobody knew anything about deposit. So that was really bad. And that question was very detailed. You won't even find it in your testing volume because now it's been so long, February 2005. I think your testing volume starts with 2006. Since then, deposit and sequestration have been tested in one multiple choice question in February of 2008. So my view on it is, I'm going to go over the rules really quickly. Like I said, think about them now. I think it was just a perfect storm that one year. New examiner, new law. I would be surprised. Right? But sometimes I'm wrong. So I get hate mail sometimes about, there's one particular thing we'll get to tomorrow, redhibition, that I say is always on the bar exam, always on the bar exam. And then one year it wasn't. 1 year in like 10 years it wasn't on the darn bar exam, and I got like all kinds of hate mail. So don't send me hate mail if I'm wrong on my guesses on what's on the bar exam. Okay, so deposit and sequestration. Again, one multiple choice question in the last 9 years. I'll tell you about that February 2005 exam so you can see how it was tested. All right, so let's talk about what there is to say about deposit. It's a contract. That's why it's in the contracts outline. The depositor, parties are depositor, depositary. The depositor gives the depositary a movable thing to hold for safekeeping, generally movables. The depositor is only holding it, so he has to return it to the depositor on demand. Excuse me, the depositary is only holding it. He has to return it to the depositor, the party giving, on demand. It's the same thing as a bailment at common law, but don't use the word bailment. Call it the contract of deposit. You give your car to the valet to park in a garage for you. You check your coat at a restaurant. These are deposits. On that exam I was telling you about, guy asks a neighbor if he can keep some tractors in the neighbor's barn. That's the contract of deposit. He's giving it over to the neighbor for safekeeping. The contract of deposit can be either onerous or gratuitous, right? That's what distinguishes it from a lease, because a lease cannot be gratuitous. So here, either onerous or gratuitous, either way, it is viewed as a contract. The only difference is that the standard of care is different. As you might imagine, there's a lower standard of care if the deposit is gratuitous. No matter what kind of deposit it is, depositary is liable for any loss sustained resulting from the breach of his standard of care. So in that example I gave you, the guy who was supposed to be holding the tractors for safekeeping left them out in the rain and they rusted, right? That's probably a breach of his duty, liable for damages. The depositary cannot use the deposited thing because, again, really the contract is for the benefit of the depositor. Otherwise it would be something else, a lease or maybe even a loan for use, which we'll talk about in a moment. However, if the depositor gives the depositary permission, either express or implied, to use the thing, then he can. So for example, in that, every one of these rules was tested in that one crazy 2005 question. So he says, a guy who's giving up the tractors in that question said, I'm giving you these tractors because they'll benefit from being cranked up every now and then. So while a depositary generally can't use the thing, that was probably an implied grant of use. They'd benefit from being cranked up. The depositary has to, bottom of page 18, return the deposited thing. And if the parties don't say where, he must return it wherever the deposit was made. If he returns it and it has fruits, he's got to return any fruits. Guy in that example rented out, leased out the tractors, and he got cash for them. You got to turn over the fruits too. Right? The depositary does not get to keep fruits. What about the timing of the return? Top of page 19. The rule is that the depositary must give it back whenever the depositor demands it. It's a demand contract. So he cannot force the depositor to take it early. If there's a term, he should wait till the term's over, but if there's no term, he has to give it over whenever the depositor requests it. Middle of page 19, you should know there are some special rules for innkeepers regarding deposit. Generally, it's considered an onerous deposit, so the innkeeper is held to a higher standard of care. But if there's a safe in the guest room, the innkeeper is not treated as a depositary. And there's a special statute limiting the innkeeper's liability for stolen goods. I mean, you see why? Right? I just can't. The only way it could be tested is on a multiple choice question, and that would be very angering, but it could happen, I suppose. Finally, bottom of page 19, sequestration is like a deposit, but it's in the context of a judicial proceeding. So it occurs by contract when the parties agree to deliver a contested thing pending the result of some judicial dispute they have. That's conventional sequestration. If the court orders it, rather than the parties contracting, pending the resolution of some judicial dispute they have, that's judicial sequestration. Again, sequestration had never been tested in the history of the bar exam until that February 2005 question. So my goal for you is knowledge of what it is when you see it, right? Be able to recognize it, set out a couple of the consequences. Loan is at the bottom of, it's just titled loan at the bottom of page 19. On to the top of page 20 is a topic that has never been tested in the history of the bar exam. We got a new law of loan in Louisiana in 2005. Before then, it hadn't been revised since 1870. Hadn't been tested in the last 10 years that we've had new law. I doubt it will be. Just recognize it in case I'm wrong. There are two different types of loans we're talking about here. One is the loan for use. This is a gratuitous contract. That's as much as I would learn about it. A loan for use is a gratuitous contract in which a lender delivers a thing to a borrower who uses it and then returns it. The gratuity is the most important part because if it were an onerous contract, it'd be a lease. Right? That's exactly what a lease is. You pay a rent, you use the thing. So here it has to be a gratuitous contract. If you have a gratuitous loan for use contract, the borrower has a few duties. He has to preserve the loaned thing as best he can. He has to use it in accordance with its nature, liable for damages if he doesn't. Usually a loan for use is of non-consumables because you have to return the thing. And if you consumed it, you wouldn't be able to return it. It is possible to have a loan for consumption, though. That's a legitimate contract in Louisiana. It's just a different type. Nearly the same thing, but the borrower here has to replace the things with others of the same kind or quality at the end of the loan for consumption. Similar to usufruct in that way, right? Usufruct over consumables. Again, I think you should go for recognition of the contract if you see it, and that's it. Finally, compromise. Now this one, right, contrast from everything else, this is heavily tested. We got a brand new law of compromise in Louisiana in August of 2007, and the bar examiner has tested it pretty frequently since then. So it is a fave of the bar examiners because it's still relatively, several years old law. The doctrine here of compromise used to be called transaction or compromise. If you're looking through some of the old testing volumes before 2007, I think you've got some 2006 exams in there. If they say transaction or compromise, that's because that's what the old law was called. Now it's just compromise. I already mentioned what it was the other day. That is, it's a contract that the parties enter into to prevent or put an end to a dispute or some uncertainty about their legal relationship. It's just a civil law word for settlement. We call it a compromise, not a settlement. There's a form requirement for a compromise in Louisiana. I've said this like 5 times by now, so here you got it again. You need a writing, or, first time I've mentioned this, a recitation in open court will be sufficient too, but generally a writing. This stuff on accord and satisfaction is newly codified as of 2007, and therefore something that the bar examiner has been a little bit hot on. The idea here is that when there's a disputed or unliquidated claim, remember unliquidated from yesterday means the existence or the amount of the debt is not certain, and a party accepts a payment with the clearly expressed written condition that acceptance extinguishes the obligation, then there's a compromise. Right? That's important to remember because it doesn't convey the typical bargaining that you'd expect for a contract. There's no, do you want to settle? Yes, I want to settle. A payment is tendered and accepted, and that's enough. That's enough to give rise to a settlement. So remember that. Finally, the reasons for which compromise may be set aside are important. A compromise is a contract, and so it's subject to most of the vices of consent: fraud, error of fact, duress. However, it cannot be set aside for error of law or lesion. Special rule here. We restrict the vices of consent for compromise. You're generally going to be hit with one of those rules. July 2007 is a good exam for you to go look at on this. It tests on the distinction between annulling a compromise for error of fact versus error of law. So spend some time and go look at that one. You can annul for error of fact. You cannot annul for error of law. And finally, a compromise does not amount to a novation. So if for some reason the compromise falls apart, the obligee can seek to enforce either the original debt or the compromise, because both still exist. He can sue on either, no novation. Almost all of those rules, again, are reworked as of 2007, so the bar examiner likes them, still wants to make sure you know the new Louisiana law, so I'd pay some attention to those. That leaves us with one last outline to do today. It's a brief one, don't worry, and that is mandate. It somehow is sandwiched between your sales and lease outline. I don't know why, but flip over to mandate. And let's finish off with that. The good news, I suppose, for you here is that you're not going to be wasting your time if you learn stuff about mandate. It is almost always tested on the bar exam. How much varies from a subpart, usually of the security devices questions, to an entire one of the 4 questions on Code 3. So it's a little bit difficult to predict how heavily it will be tested, but it will definitely be on your exam in some way. And there are 3 or 4 things that are tested over and over and over. I'll highlight those as we go along, spend less time on the rest. Of course, you need to know what mandate is. It's just a form of representation. One party represents the other in his legal relations, does not perform himself, but allows somebody else to perform for him. And a mandate is the contract between the principal and the mandatory that confers authority to engage in transactions on the mandatory. If you're common law trained student, it's agency, but don't call it agency here. You call it mandate here. And don't call it principal and agent, call them principal and mandatory. Everybody, even if you focused, on the agency words in your business associations class, for the bar exam, you got to show that you know Louisiana law. So use the word mandate, the words mandate and mandatory. All right, so we talked about representation. Mandate is just a representation that arises by contract. So what the mandatory can do depends on what the parties agreed to, what the contract authorizes him to do. The form for a mandate is tested very often, so know that. The general rule is that there is no form requirement for a mandate. Even an oral mandate would be okay. But here the equal dignities doctrine applies. So I mentioned it yesterday in another context, right? That is, if the act the mandatory is authorized to do has to be in a certain form, then so must the mandate. For example, to sell an immovable, you need a writing. So a mandate to sell an immovable has to be in writing too, an act of equal dignity. Tested very frequently, tested heavily on February 2007, so go back and look at that if you want a nice example. There's an additional requirement that's tested pretty often. I'm skipping a little bit down to the bottom of page 1 now, and that is that if the mandatory is authorized to sell, acquire even, encumber or lease any property, movable or immovable, the authority has to be given expressly. Right? Distinguish between a writing requirement and an expression requirement. If you want to do anything with property, movable or immovable, selling or buying, then the mandate has to be express. All right, now go back up to the general rule. Assuming that we have proper form here, in the absence of some special rule, general authority in a mandate is enough. So what's the difference? General authority as opposed to express authority. General authority on the bar exam is always tested like this. I'm going out of town, act for me in all of my transactions. That's general. I don't say what the transactions are. Act for me in all of my affairs. That's general authority. That's normally good enough. The times that it's not good enough is this list at the bottom of page 1. That is, there are several situations for which giving the mandatory general authority is not going to be sufficient. Memorize this laundry list. Every single one has been tested. I just mentioned the first one to you. I want to beat the horse again. On the first one, though, usually in the civil code, when we're talking about special rules, we have special rules for alienating, encumbering, or leasing property. Here, it's acquiring too, right? So even a mandate to buy movable property requires express authority. It doesn't have to be in writing, but it requires express authority. That's the most tested one, but every single one has been tested here. Making an inter vivos donation, accepting a succession, contracting a loan, becoming a surety, I won't go on. All of them have been tested. The health decisions was only through a multiple choice question, but many of the other ones have been tested through essay, especially F and G. Promissory notes, because you're going to be tested on promissory notes and prescription on them and all that in Code 3, and compromises. Right? Again, you're already going to be tested on compromise in Code 3, so very easy for the bar examiner to throw that in as well. Know all of those. All right, well, now that you remember the basics about what mandate is, let's look a little bit more at the specific relationships involved in a mandate. It lets the mandatory act for the principal and allows him to enter contracts with third parties. So it's basically, I'm sort of before 2A here, the relationship between the principal and the mandatory. Basically, mandate is a three-part relationship, and the law in Louisiana regulates all three. Relationship between the mandatory and the principal, which is what's here. Relationship between the mandatory and the third party, and relationship between the principal and the third party. On the exam, you need to be thinking about which category you're talking about. What is the question asking you? Is it asking you about principal mandatory, mandatory third party, principal third party, because they're distinct rules. So categorize it. I think you'll serve yourself by doing so. Let's talk about the first relationship, the core relationship, the rights and duties between mandatory and principal. The mandatory's duty is to act with prudence and diligence. And so you'll remember that means he's liable to the principal with whom he contracted if he breaches that duty. But remember, mandate can be onerous or gratuitous, doing it out of the kindness of your heart or you're getting paid for it. Obviously, your liability is less if the mandate is gratuitous. Other duties of the mandatory to perform are listed here. You have to notify the principal that you're going to appoint a substitute if you cannot perform, if you don't want to perform. Bottom of page 2, the mandatory has a duty to give information to the principal to account for his performance. Mandatory has the duty to deliver to the principal anything he gets under the mandate. Those, not so much. Not so much testing of those. But bottom of page 4, acts exceeding authority, every exam. So star that. You want to know that. Number 4, bottom of page 2. The rule is that the mandatory that exceeds his authority is liable to the principal for any loss that he causes. And if the mandatory suffers his own loss because he exceeded his authority, too bad. He cannot recover that unless the principal ratifies the act. Now, what does it mean to exceed your authority? Don't forget here that you won't be found to have exceeded your authority if the results of your act are more advantageous than what was authorized, right? Even if it was technically unauthorized, if it ended well, right, then obviously that's not considered a breach. Remember, none of this tells you what happens with regard to the third party when the mandatory exceeds his authority. We're only talking mandatory principal right now. Still, as between the mandatory and the principal, top of page 3, the principal has some duties as well. He's bound by all obligations that the mandatory contracts for him that were authorized under the mandate. And he's even bound for acts done after the mandate terminated, as long as the mandatory acted without knowing of the termination. As I said a couple minutes ago, the principal is not bound by any acts of the mandatory that are unauthorized, unless he ratifies them, of course. Duty to reimburse. The principal has to reimburse the mandatory for his expenses, to pay him any money that's due if it was an onerous mandate. That's a possibility. Anything the principal promised by contract to pay. All right, so those are the rules between mandatory and principal. It gets more complicated, remember, when you start analyzing relationships with third parties, particularly if you have a mandatory exceeding his authority. So let's recall those rules now. And the central question that you have to ask here, the most important one, is what did the mandatory tell the third party? That's what drives the analysis. There are 3 possibilities of what the mandatory told the third party. First possibility is that it was a disclosed mandate, disclosed principal. This is usually called a fully disclosed mandate. So you'll remember that mandatory says, I'm an agent for Joe Smith, right? You're disclosing the mandate, you're disclosing the principal. Second possibility is an undisclosed mandate. It's the opposite. Mandatory just contracts and doesn't say anything about the existence of a mandate or the identity of the principal. Third is a disclosed mandate, undisclosed principal, frequently referred to as a partially disclosed mandate. This is where you say, I'm acting as an agent for another, but you don't name the person, right? So you disclose the mandate, but not the principal. Who cares? Well, different duties to the third party depending on what you have. So let's take first the mandatory's obligations to the third party. If you have a fully disclosed mandate, disclosed principal, the mandatory has no personal responsibility to the third party. Only the principal is bound. If you have an undisclosed mandate, the mandatory is personally bound. Right, which makes sense, remember, because he's entered into the contract in his own name. Principal had no idea that he wasn't the guy. For a partially disclosed mandate, it's the intermediate rule. The mandatory is personally bound unless and until he ever divulges the identity of the principal. Right, the reason for all these rules is simple. If you memorize it, you'll memorize all the rules. The third party agreed to deal with the mandatory, and where he doesn't name the principal, he's expecting the mandatory to be liable. So unless and until that principal is named, we'll hold the mandatory. Those are all general rules through the bottom of page 3, and they all assume that the mandatory acted properly. If the mandatory exceeds his authority, then we're on the top of page 4. Then he's liable to the principal, always, in all but 2 scenarios. Right. General rule for exceeding authority, mandatory liable to the principal, I meant to the third party, I'm sorry, under all but 2 scenarios. Two times he won't be liable to the third party. First, when the third party knew the mandatory was exceeding his authority, let him go on anyway. Or two, when the principal subsequently ratifies the contract. If either of those two is met, the mandatory can't be held to the third party, but generally they're not. And so the mandatory usually is held to the third party for exceeding his authority. All right, those are the mandatory's duties to the third party. Now, what about the principal's duties to the third party? We start there with number C, or letter C, on page 4. The general rule is that the principal is bound to the third party for everything the mandatory did that was authorized. And then I really want you to know this doctrine of apparent authority, C2. That is, even if there was no mandate, that's what this is about. There's no mandate whatsoever. If a principal does something that causes some third party to believe that somebody's acting on his behalf, the principal will be bound to the third party. This doctrine is called apparent authority. Right? The mandatory actually didn't have any authority, but it's apparent authority. That was tested pretty heavily and in a tricky manner in July 2013, last summer. So if I were you, go back and look at that. It's a nice example of apparent authority. Look back at that exam. There's no mandate whatsoever, but the principal says something that tricks the third party into believing. Then we may apply mandate principles. Finally, what are the obligations of the third party to the principal? Well, the third party is bound to comply with the obligations contracted by the mandatory in a fully disclosed and partially disclosed mandate. And even in undisclosed mandates, the third party is bound to the principal unless the obligation is strictly personal. In other words, not heritable. Last thing that we need to think about on mandate, so this Roman numeral 4, termination of mandate, star it, highlight it, whatever, heavily tested when mandate is tested. So those form requirements and expression requirements and termination are the big things on mandate that I would spend my time on. So on page 4 and 5, know these rules. The most basic rule is at the bottom of page 4, heavily tested, that is, mandate terminates on the death of either party, interdiction of either party, or on notice of termination by either party. Then unfortunately the bar examiner has tested every single one of these special exceptions on page 5 as well. That is, even though mandate is terminated under the general rule, there are 4 situations in which the mandatory's authority will continue on a little bit longer. First, when the third party enters into a contract with the mandatory in good faith, not knowing of the termination, the mandatory still has authority, principal will still be bound. Second, on page 5, if the mandate ends because the principal has died, the mandatory has the right to, indeed he has the duty under mandate law, to complete any undertakings that he's already begun, if not doing so would hurt the principal's interest. Sort of a, finish what you started rule if it ends by death. You have to complete what you undertook. That has been tested relatively recently. Third, the mandatory has authority at least as to third persons, even after termination of the mandate, if the termination doesn't appear on the public records. All right, so when we're speaking about immovable property, obviously, we need a termination of the mandate on the public records as well to bind third parties. And finally, number 4, if the mandatory doesn't know of the termination yet, any contracts he enters into in good faith can be enforced. They are binding on the principal. You see the difference between 1 and 4 here, right? In 1, the third party is not notified of the termination. In 4, the mandatory is not notified or is unaware of the termination. So close, but a slight distinction between the two. That leaves us only one more thing to talk about. It's at the bottom of page 5, management of the affairs of another. Here's another one. We added it to the outline for the very first time this year. It's testable. On Code 3, it's on the list of bar examiner subjects that may be tested, has never been tested on the bar exam thus far, so that's one problem with it, or thing for you to think about involving it. Don't spend tons of time here. 2, I also want you to put a line or a box around it or whatever to not confuse yourself. It's in this section of the outline on mandate, but it's not a mandate. Right? A mandate is a contract. I really really don't want you to be confused by that. It's here because it's governed by some of the rules of mandate, However, a mandate, the most important thing for you to know about a mandate is that it's a contract, and management of the affairs of another is not a contract. So just be careful with its placement. Let me go over the basics of it quickly, in keeping with the fact that it's never been tested. The basic idea of management of the affairs of another, in law school you called it negotiorum gestio, is that somebody acts for you without a mandate, believing that you would approve of the activities. So for example, I'm out of town, you know that a hurricane is bearing down on Baton Rouge, and so at a cost of $300, you go and buy a bunch of sandbags, make a sandbag wall around my house, and I'm lucky to have you because you prevent my house from flooding. Every other house in the neighborhood flooded, right, but you prevent my house from flooding. Then you ask me for the $200 that you spent to construct this sandbag wall, and I say, no way, I didn't tell you you can do that. We don't have a mandate, but you'll probably be able to collect from me under this doctrine, management of the affairs of another. It's not a mandate because it's not a contract. It's an obligation that arises without agreement here. However, to the extent, this is B, we can apply the mandate rules, we will. But I think that's much less important than what's after that, C, D, and E, special rules. In other words, our ability to apply the mandate rules is trumped by these special rules anyway. So take a look at, and I would especially know, if I were going to know anything about this, D and E. The manager must act as a prudent administrator. Right, so you can't damage my property, you have to deal with it as a prudent administrator. And E, even though the manager here did not act with authority, if it meets the requirements of a management of affairs of another, he gets back only his necessary and useful expenses. Right, so if you bought fancy, beautiful, colored sandbags that were not necessary, you're not going to get money back for that. Again, never been tested and not exactly a mandate, but there's the possibility. I'll be back with you one more time tomorrow, and we'll finish off with sales and lease.